Good morning, everyone. Welcome to Making Law Simple. My name is David Helm. I am a licensed practicing attorney in the state of Michigan. And today is the day that we're here. I started streaming because of this case. Uh, I've had the YouTube channel for like 5 years prior. I did some small little videos and things like that. This is why I started live streaming, was this case. And we are finally here to the first one, anyways. James and Jennifer Crumbley were always going to be tried together up until about a month ago. And now we are starting with Jennifer Crumbley's trial today. A jury has been selected. It consists of, let me get the demographics, 17 jurors total. There are 5 alternates, 10 women, 7 men, 1 black man. Everyone else seems to be white. They are mostly parents. All of them said that they were okay with guns, that they have guns in the house, things like that. Some of them said they went hunting and claimed to have no opinion regarding Jennifer one way or the other until they hear the evidence. One concerning juror, if I had to say, was concerning. If you guys remember my update from a couple of days ago, and I was talking about that there was a juror that said when she thought about the case, she got enraged or furious or something like that. Was she appears to still be on the jury. Now, she was favorable in her opinions on many things. She keeps a gun at home. Kids can get, things past their parents, all kinds of stuff like that. It was that one statement that caused me to pause. But the defense, I believe, appeared that they liked other things that she had to say. So she's on the jury. One of the interesting things was after the jury was selected, defense counsel asked the prosecutor who they planned on calling this morning as their first witnesses. The prosecutor said, "We don't know yet." There was an objection from the defense, and the judge instructed the prosecutor that this is not a small little thing. We need to know who your witnesses are. The defense needs to know who your witnesses are, and compelled the prosecution to identify the witnesses that they intend to call today by 9 p.m. last night. So we're assuming over to the defense. That wasn't made public or anything. So we're assuming that that's going to happen. Also, I will say that the state intends on calling 20 to 25 witnesses, although I don't know all of their names. Most of them appear to be police officers. We do know that they're going to try to call 2 teachers. The question is still up in the air as to whether or not Ethan is going to be called, since he has filed an intent or a notice of intent to plead the 5th. So that'll be very interesting. I know there was a motion brought by the defense essentially saying, if you can't call Ethan, then you can't admit his journals. You can't admit the text messages because my client has the right to cross-examine those things. And if he's not on the stand, she can't. And I don't know if the court has made a ruling on that, if she's going to make a ruling in sort of a public forum or not, and when we might actually hear a ruling on that. And just by way of technical spec setup, I was really hoping to get my cameras in the courtroom. The court last minute decided to do a raffle, a blind draw, I guess. Random selection is what the clerk said. WXYZ, a local ABC affiliate, was able to get their cameras in the courtroom. Speaking with that producer, she indicated that the pool feed would be made available to the big networks and not me. Court issued then an order that says whoever gets access to the pool gets access to the pool, and everyone else gets a Zoom feed. So we're sitting here on the Zoom feed right now, waiting for court to start. I'm also looking for alternative coverage. I'm not above going to LNC Word if we need to cover this trial. I was really hoping not to, but we will have this case one way or the other. We will bring you this case. If it has to be Zoom, it has to be Zoom, but I'm hoping not. So I haven't been following this case much, but I live in Michigan and I feel like I should follow it. It's been a while since I've watched a trial. Well, I'm glad you're here. So this is the mother. not the father and the mother, just the mother of the Oxford school shooting. Ethan Crumbley on November 30th, 2021. Um, After a meeting with the counselor and his parents, went into the bathroom, retrieved a handgun from his bag, and started shooting at fellow students, killing 4, injuring 9, I want to say. And Ethan and Jennifer Crumley have been charged with involuntary manslaughter as a result of that. Now, involuntary manslaughter is kind of a tricky thing for these particular parents. So, if we look at the jury instructions for involuntary manslaughter, uh, says the first element is that the defendant must have caused the death of the decedent. That is, that the decedent died as a result of whatever the defendant did. Second, in doing this act that caused the decedent's death, the defendant acted in a grossly negligent manner. The problem is the causation for me, because you have the intentional wrongful acts of another that's intervening in the parent's responsibility, right? Generally, you are not held accountable for the intentional wrongful acts of a child. What was interesting is the judge, when she was questioning the jury on Tuesday about their, biasness and things like that, she had asked the jurors, one in particular, if your child, he identified they had a 24-year-old. She said, okay, if your 24-year-old stole your firearm and shot somebody, should you be responsible? And the juror said, no, he's an adult. And she said, okay, well, now let's assume he's 17. The juror fired back like, well, I don't have a 17-year-old. I have a 24-year-old. He wasn't getting the hypothetical. But that's the sort of thing that we're talking about here. And I think the judge was very careful to, without arguing for the defense, make it clear that guns are lawful. It's lawful to have a gun in your home. It's lawful to take your son shooting. It's lawful, just because a child does something doesn't mean that the parents are criminally responsible across the board and things like that. So it was an interesting dynamic to watch the jury instruction or the jury selection process. Let's see. This case interested me from the time that they were arrested. I was intrigued because I don't know if you could prove involuntary manslaughter for this. Also had some doubts in MA v. Carter. Yeah, so that's the thing. Like the one case that the prosecution is hanging their hat on. I have a breakdown of involuntary manslaughter in Michigan when this case first happened. But the one case I think the prosecutor's hanging their hat on is a case that involves a gentleman who left his 2 underage kids. They were like 7 and 8 or 6 and 7 or something like that in a locked room. And in that locked room was a loaded shotgun. And one accidentally killed the other. And they held the guy criminally responsible. And it went to the Court of Appeals, and I believe even the Michigan Supreme Court. And they said, well, for like this case only, we can understand how we're going to hold the father responsible for involuntary manslaughter. But specifically, the court said like this type of case only, which this isn't. And also, you didn't have the intentional wrongful acts of a third party intervening. You had the negligent acts of a child intervening, and that's different. So we're not talking about the negligent acts of Ethan Crumbley intervening. We're talking about the intentional wrongful acts of Ethan Crumbley intervening, and that changes the thing. Going off topic for a second, watching Tom. Yeah, I was watching Tom and Tom's CPU for a minute too. I'm gonna do a breakdown on the whole Turtle Boy situation here, maybe this afternoon after this trial and stuff. See, that's the thing. Hopefully, these jurors can separate their emotions. The one veterinarian lady that's sitting on the jury, I think she's too emotional. And I would have booted her as a defense counsel. Now, I don't know if they were concerned about other jurors more, right? You look at like, well, that's the first to go, and then that guy, And then, if we still have a peremptory challenge left, we'll get that veterinarian off. That might have been what happened. Or for some reason they liked her. I don't know. It's not my trial strategy. I just know I would not have liked her on if I had options to remove her. When there are substantial records documenting parents neglecting professional recommendations, that's something that needs to consider in the law. Maybe, first of all, I don't think there are substantial records documenting a parent's neglect of professional recommendations in this case, but let's assume there are. Is it child neglect, or does as the prosecutors say, does the parent have a duty to the public at large to protect the public at large from their dangerous child? Is that a duty that parents have in general? In general, do parents have a duty to protect? Because I don't think there is one. There is no legal duty, as far as I know, that parents have to protect the public at large from their dangerous children. Assuming you know that their child is dangerous, is there still a duty to do it? Do you have an opinion as to the son being charged as an adult? No, I believe it's appropriate to charge him as an adult. I have a problem with him being sentenced to life without the possibility of parole, because I believe that is fundamentally cruel and unusual, as the state has said, or not the state, the Supreme Court has said that sentencing a juvenile for whatever crime to life without the possibility of parole is cruel and unusual given the age of the person that committed the act. So I have a problem with that. Not necessarily with charging him with an adult. It was a heinous crime. He's going to go to prison. He's going to go for a while. So the thing is, when you charge someone as a juvenile, the goal is not punishment or to lock them away. The goal is to get them treatment. Most juvenile charges, they don't go to prison. They don't go to like Children's Village. They get counseling. They get guidance from their parents. They're under strict probationary terms and things like that. That's not appropriate in this case. This kid needs to go to prison. So charging him as an adult was fine. But I think at the end of the day, he still should have the opportunity for parole. Not saying he's going to get it. He might never get it. But given his age, he should absolutely have the possibility of parole. And good morning, everybody filtering in the chat. I see you all. I'm just distracted by the court. I think we might be going live here. Here we go.
All 17 jurors are yours.
Your Honor, I have a quick.
Let me know if you guys can hear it.
I made yesterday.
We're not on the record.
Oh, sorry.
And why don't we wait here?
Okay, well, I just wanted to see if you wanted me to do that now or later. I made.
Can you guys hear it?
It was at the bench, so it's not on the record.
Oh, okay. Well, if you want to make a record, we could do that now, or we could. Your client's on her way up.
Yeah, or we can do it later. I just was.
Yeah, it's up to you. I just wanted you to know we aren't on the record yet.
Okay,
so.
yeah.
I didn't catch the motion that they were trying to talk about. You can hear it well. Okay, good. So I don't know that there's. I didn't see any cameras being set up, so I'm wondering if there is cameras.
I can put this. Adjust you to the court. Move down for it, but I just need to put it on the record. I don't care if we do that later. I just need to make sure we do it.
Yeah, they allow WXYZ to get their cameras in the courtroom, not mine, and there's no feed. Except this.
Okay. These ones are good.
So disappointing.
Did you guys test this stuff out?
Yes.
Is it all working?
Yes.
Okay, that's the second miracle today.
Yes.
The third is my audio levels, apparently. Audio way better than the video.
Okay, these are just.
Yeah.
Exhibits that we're adding on.
That's why I wanted to hook
Oh,
up to the
can
audio
you write
from the
these
court
exhibits
because it's pretty
down?
good.
Yeah, no, go back to the last page of that.
All right, there's Jennifer Crumbley. I said that she looked like a grandmother. It's kind of hard to see it in this image, but her hair is gray. She's gained a lot of weight. The trial is slated to last about 2 to 3 weeks. The judge had made it abundantly clear that once the trial starts, she is going to move it along quickly. The judge does not want this tied up beyond 2 weeks.
They've already got their names.
Oh, well, welcome, Becca. I'm super excited as well.
Okay. Let's grab your chair.
Your Honor, calling People versus Jennifer Crumbley, case number 222799990FH.
Good morning, Your Honor. Karen McDonald.
She looks
on behalf
very
of the people.
nervous.
Thank you. Mark Keese on behalf of People.
And good morning, Your Honor. I'm Shannon Smith on behalf of Jennifer Crumbley, who stands to my right.
Good morning, Your Honor. Sean Godwin, P74500 for Jennifer Crumbley.
Good morning. All 17 jurors are here. We're going to bring them in. I'm going to swear them in. I wanted to mention to you that having a bench conference isn't as convenient as it may have been in the past. Media has indicated that I should ask them to cut the microphones at a time when we do a bench conference, but I also want to know that
That was my request.
Want to note that 16 and 17 are kind of up in my grill here. So it's difficult to have a bench conference. We might have to step into the hallway or do something, but I think that the two.
So they've
jurors who are
added 2
sitting right
additional
here are
jury
able
seats
to
is
hear
what she's talking
what's
about. And
said.
they're right up on
Keep
top
that
of the
in mind.
witness.
All right.
They're literally like
All right.
staring
Anything
down
else
the
you wanted to make a
witness.
record?
Your Honor, I just
Imagine
wanted to make a very fast record.
Like a
that
juror
yesterday
sitting
during
right
jury
here as you're
selection,
testifying.
I made an objection when Ms. McDonald stated she can prove this case. The court ended up instructing Ms. McDonald to move on and ask a question about if they would hold her to her burden. I just wanted to place that objection on the record. I
don't recall specifically what was said, but obviously the record speaks for itself. I was intent on moving on, asking questions, so I don't remember exactly what was said on the record.
Thank you, Judge. It was made in the course of jury selection's conversation with the jurors, and prosecutor can't prove the case, and why are we here to begin with? But this court did instruct the jurors appropriately. I believe jury selection process was conducted in accordance with all court rules and statutes.
All right.
I have one brief thing.
Okay.
Some of your attention that one individual who was subpoenaed as a witness is in court today. I asked for a mutual sequestration of all witnesses except for the officers in charge of the investigation.
I have no knowledge of who that is.
Well, I certainly don't either. There's a mutual sequestration order, correct?
I'm not
Yeah,
going to
there
be able to
is.
pause it, folks.
Who's
Okay.
the-
Megan Mirowitz.
Okay.
Oh, she's a
I don't
witness?
even know who Megan Mirowitz is.
Megan
She said
Mirowitz
she
is a
step
witness?
out.
She was in for jury selection. Oh my God.
Oh,
Well, I certainly don't know who that is.
Why is she a witness?
Is she on somebody's witness list?
She's
on the
on-
witness, Judge.
Yeah,
On your witness
and
list?
they've subpoenaed her, so, okay.
All right.
Why
anyone
was she
who's a
there for jury?
witness, Can't remain. There's a sequestration order. I want to caution everyone sitting here to be as quiet as possible, as respectful as possible, as unemotional as possible. I can see you all from up here, but I don't want anybody to be.
Yeah, they were
eating or
friends in
drinking.
prison, but why is she?
Additionally,
Why was she in the
With the
courtroom?
exception of the media, who is allowed to take
Megan
pictures with their
Mirowitz
cell phone. I don't want
Was a
anyone to
criminal
have their
defendant
cell
on a
phone
case I
out.
covered a couple of months ago.
But I expect poker faces from the audience.
She was in prison with Jennifer and made friends with her and said that Jennifer was like a mother
So the
figure
court is
for
where
her
there
while
are
she was
parents
in
and
jail.
deceased in the courtroom.
I understand.
And going back to Mr. Mirowitz, she's the defendant's friend. She's subpoenaed because of statements made. We didn't ask her to be here for jury selection. In fact, we told her she didn't have to come until call. So
Okay.
she was not invited by the prosecutor's office to sit through this.
Okay.
And-
All right. My statement was more of a general statement about people trying to, I don't want people wearing their heart on their sleeve. I know it's hard to do, but it impacts the jury. Yeah. Yeah, I'm not in charge of witnesses. You guys are in charge of your witnesses.
I had
There is a
asked
mutual
Megan about
sequestration
that. I had
order,
called
so
her when I
if-
first heard
if
about
the
the
witness were to
division
sit
between the
through,
parties, and she said
part of the
that
trial, they may
Jennifer
easily not
had
be
made
permitted to testify, so.
no statements to
Right.
her.
Yeah,
If
absolutely.
there's any
Okay.
breakdown
We agree.
between her and
I didn't
James.
realize she was back there, so.
Yeah, no, I understand, and you may not have ever seen or met some of your witnesses, so I understand that. Are you ready for the jury?
Yes, Judge.
That's interesting. Yeah, Megan's mom is a member of our channel. Oh, is Law and Cuck's feed up? Okay, let me pull it. Oh, it's the same feed. Law, really? Law and Crime? Okay, WXYZ, where are your cameras? I thought you were sending them out. They're going to keep them, not stream them?
I know. Okay. I know all of this stuff. Okay. But listen, I've been here for 2 years. I know the laws inside and out. I know the evidence inside and out. Okay. Okay. And it's when the judge is saying the emotional thing, you've got to watch it too. Okay.
Yeah, apparently she had a bit of a breakdown.
You look great.
Hang on, folks.
You're gonna
Right
be
back.
fine. Okay.
All rise for the jury.
You've got the water. You've got chances. You can go towards.
Good morning. Thank you for being prompt. You may be seated. I'm going to, I know you noticed that the media is here today. I want to reiterate that they will not be taking your picture, videotaping you, and they do not have your names. I also want to tell you that I'm going to be reading instructions to you, and you're going to get a written copy of the instructions, so don't try to write down what I'm going to say, all right? Members of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I'm going to ask you to swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Could you stand and raise your right hand? Here is your oath. Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you're discharged by the court from further deliberation, you will render a true verdict, and you will render your verdict only on the evidence introduced in accordance with the instructions of the court, so help you God. Thank you. You may be seated. You'll be given a written copy of these instructions that I'm going to read.
Sorry, yes, we are live. We are
At the end
live.
of the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I'll provide you with a copy of
That's
my
what I've been
final
saying,
instructions
X-Comer.
for your use during your
What if
deliberation.
the child took the parent's
I'm going
car
to
and
explain
intentionally
some of
ran
the
somebody
legal
down?
principles you'll need to know, and the procedure will follow in this trial. The defendant is charged in counts 1 through 4 with involuntary manslaughter. The prosecutor has alleged
This is
two
about the
separate
biggest.
theories of defendant's guilt, which may be established under either or both of the two theories. The first theory of involuntary manslaughter is doing a grossly negligent act causing death. To prove this charge under the first theory, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, in count 1, that the defendant caused the death of Madison Baldwin. In count 2, the defendant caused the death of Tate Meyer. In count 3, the defendant caused the death of Hannah St. Juliana. And in count 4, the defendant caused the death of Justin Schilling. That is, that Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. There may be more than one cause of death. It's not enough that the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. Second, in doing that, the act that caused Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling's death, the defendant acted in a grossly negligent manner. Gross negligence means more than carelessness. It means willfully disregarding results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. As previously noted, the prosecutor has alleged two separate theories of defendant's guilt. The second theory is gross negligence in failing to perform a legal duty. In the second theory, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to prevent their minor child from
I have a different
intentionally
feed.
harming others or prevent the minor child from so conducting themselves in a way that creates an unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin, as to count one,
I'm going to stop this. Sorry. I'm going to stop this and upload the other feed. Hang on a second. Bring up the other feed. Oh, not that. Share screen.
That the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin, as to count one, Tate Meyer, as to count two, Hannah St. Juliana, as to count three, and Justin Schilling, as to count four, were directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling died as a result
Parents will
of
not be
defendant's
testifying
failure
against
to
each other.
exercise reasonable care to control her minor child, so as to prevent him from intentionally harming others or from so conducting himself so as to create an unreasonable
I have
risk
it
of bodily
boosted.
harm to
Is it
others,
too quiet?
knowing that she has the ability to control her child, knowing of the necessity and opportunity to do so. There may be more than one cause of death. It's not enough that the defendant's act made it possible for the death to occur. In order to find
We're
that the
back
deaths
with
of Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. With respect to the alternative theories, it's not necessary that you all agree on which theory.
The other feed was
As
louder.
long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt.
Do we want the other feed
A person
that has
accused
worse
of a crime
video,
is presumed to be
but
innocent.
louder?
This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything.
I'm going to say turn
If
your
you find
volume
that
up.
The prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. The
Here, is
trial
this
follows
better?
this procedure.
Is my volume
First,
better
the
compared to the
prosecutor makes
court?
an opening statement where they give their theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes theirs, or she may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of their evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, they are not evidence.
We'll see
They're
how
only
this
meant to help you
goes.
understand the evidence and the way each side sees the case. You
We'll
must
see how
base your
this
verdict
goes
only on the
compared
evidence.
to when others are speaking, the witness.
Our
and
responsibilities as the
things like
judge
that.
in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as they give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's disability, race, national origin or
Brandon,
ethnicity,
My volume
gender,
compared to the
gender
court.
identity or sexual orientation, or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you think about these questions. Well, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort
I'm
to tell
slightly
the
low
truth?
now.
Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you
I
judge
turned it up a
his or her
touch.
testimony? Does the witness have any bias or prejudice or any personal interest in how this case is
Oh,
decided?
it's locked in.
Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case?
Yeah, but
When
not
it's
by
time for you
much.
to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits. and the
Okay, how about now
evidence,
compared to
and
the court?
anything else I tell you to consider
Is my
as
balance
evidence.
good? I turned off the automatic balancing because Brandon was bitching about it.
The questions the lawyers ask are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may have not been fully explored. I usually assume that if I don't understand something that a witness is saying, that one of the jurors might be sharing that confusion. So if you can't hear something that is being said or presented, or if you can't see or hear a witness, please raise your hand immediately. All right?
Well,
During the
I don't know
lawyers
that
may
this is a
object to
directed
certain
verdict
questions or
case.
Statements made by the other lawyers or witnesses. I'll rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I might have to take care of other matters that have nothing to do with this case. Pay attention, do not pay attention to those interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I'll send you to the jury room for that purpose. You're in 2 different jury rooms right now, but you'll obviously be in one jury room when there's 12 of you deliberating. When it's time for you to decide the case, I'll send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all the jurors are there.
Yes, jurors get
You
to
must
take
not
notes
talk to the
and
defendant,
ask
the lawyers,
questions.
the witnesses, or anyone who may be connected to the case. You might see one of the lawyers in the hallway and they won't even say good morning to you. There's a reason for that. This means that you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you're not allowed to discuss the case. If they continue, leave. Report the incident.
What was interesting is several of the jurors knew that this was a very first time that parents were being charged. So they do know. Like the other jurors said it aloud. Like this is a precedent case. The parents had never been charged before. Those jurors didn't make it onto the jury. They were removed, but still, so everyone knows.
Court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone.
There are no
Please
lesser
wear your
included.
badges the entire time you're in
This is the
courthouse.
lowest.
Right? During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you must consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider has to meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom doesn't have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side or another. These restrictions start now and continue until I discharge you from jury service. It's your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case.
It goes a little deeper than
including
that.
Investigation
Wrestler's
or
mom.
experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it's necessary for you to view the scene, the court staff will take you there as a group under court supervision.
If you're just joining us, don't forget to take the poll.
Any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you're not discussing the case with someone else, you may not post any information about the case on social media websites or any other matter. If you discover that a juror has violated my instructions, please report it to my staff immediately. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it doesn't distract you from paying attention to all the evidence. Sometimes people are taking notes and they don't hear the next question and answer. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. You must give them to my clerk when you leave each evening. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. At this point, I always like to tell jurors, it's possible to replay a witness's testimony upon your request. We have our IT department come up off our videotape courtroom, so the witness's testimony is being videotaped. I'd like to tell you this caveat. You would be required to hear the entire witness's testimony, not just the portion of interest. You can't all fast forward to a certain part and all yell, aha. Okay, it's the only way it's fair to both sides. If we hear a witness's testimony, we have to hear the entire thing, all right? There is more than one defendant involved in this matter. You should consider only the evidence presented in this defendant's trial. Each is entitled to have his or her case decided on the evidence and the law that applies.
Yeah, I would say 78.
You can see that we've chosen a jury of 17. After you've heard all the evidence in my instructions.
They do
the
allow
trial has to
jury
decide which
questions.
You will be dismissed to form a jury of 12.
Michigan does have jury
There's
questions.
17 of you because life happens, all right? But I did order you all last night to stay healthy, so I hope you're doing fine. All right. Possible penalty should not influence your decision. If you find the defendant guilty, it is my duty to fix the penalty within the limits provided by law. I'll definitely be giving you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I'll give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions.
Thank you, Aaron Heck, for the $20 lunch money.
They are the law you must follow. After my final instructions, you'll go to the jury room to decide on your verdict. The verdict must be unanimous. That means each juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to maintain an open mind and not make a decision about anything in this case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid
Golden
reaching
mirror.
conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours.
Do we have a verdict in the other
Did
treehouse?
everyone fill out a menu for lunch this morning? I guess I didn't ask my staff whether there were any special dietary needs. Those could be accommodated by tomorrow, but maybe not today. So everybody filled that out. All right.
Do we have a
So now
verdict
we
in
move
the other
to
treehouse
openings,
case?
and, as I said earlier, openings are not evidence. They're how we decide.
Curious to see how the state approaches this. I was surprised by how Karen Reed phrased the opening statements or the questions for the jury.
I want to introduce you to Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. They died on November the 30th of 2021. They weren't in a car crash. They weren't sick. They were murdered in an act of terror committed by Jennifer Crumbley's 15-year-old son. Jennifer Crumbley didn't pull the trigger that day, but she is responsible for those deaths. These kids were gunned down inside Oxford High School with this gun. It's a 6-hour 9mm handgun purchased 4 days before the shooting by James Crumbley, Jennifer's husband and father of the school shooter. This was a purchase celebrated by Jennifer on Instagram. These are her words. This is her post. Mom and son Dave testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye. The evidence will
Hey,
prove
Joe.
that by the time this gun was bought, the school shooter was in a downward spiral that had begun months before. The evidence will also show you that Jennifer Crumbley was aware of that. Despite her knowledge of his deteriorating mental crisis, despite her knowledge of his growing social isolation, despite the fact that it is illegal for a 15-year-old to walk into a gun store and walk out with a handgun by himself, this gun was gifted. You will also learn that despite all of that background, this firearm was not secured in a way to prevent her son from gaining access to it. The evidence will also prove to you that even with all of that, on November the 30th, Jennifer Crumbley was still given the opportunity to prevent these murders from ever happening. Instead, she chose to do nothing. This drawing, this math worksheet, was sent to her November the 30th, 2021 at 9:30 in the morning. That's more than 3 hours before the first shot was fired. These writings, that drawing, created by her son. She was sent this by her son's school counselor when he requested an immediate meeting with her at the school that day. He requested that meeting because this drawing, those words, suggest both weapon and injury, even to someone with only limited knowledge of the shooter. Apparently, that raised an alarm with Jennifer Crumbley because she did go to the meeting with her husband, but before she did, she privately communicated her own concern with her husband. This will be admitted in evidence throughout the trial. This is a portion of a Facebook Messenger thread from Jennifer to James Crumbley. Jennifer, words in blue. Emergency, November 30th, 2021, 9:35 a.m. Then she sent the picture to James. His response, my God, WTF. And then he wrote back about the vet. He was at their barn, worried about their horse. Jennifer's response, he said he was distraught about last night. And then, I'm very concerned, headed to his school. That's at 10:12 a.m. Yet, despite their private concerns, the evidence presented in this trial will show to you that that meeting at the school was nothing like that school counselor or the dean of students who sat in on the meeting had ever experienced before. Those two individuals, even with their limited knowledge of that drawing, had expected the defendant or her husband to take their son home and set an appointment with the mental health professional. But they didn't. You see, you will learn that these kind of meetings, when they occur with parents, can last an hour or longer. This one was abruptly ended by Jennifer Crumbley after just over 11 minutes. And then she left. You see, this drawing alarmed everyone who saw it, including those who only knew the Crumbleys in limited settings, or even to those who had never met their son before. The two people in the world with all of the information, all of the background, to put this drawing into context were James and Jennifer Crumbley. And you will learn that in that meeting, they didn't share any of it. They didn't say anything about the fact that that firearm was identical to the 6-hour 9mm. Identical. They didn't mention how that gun was stored. They didn't mention anything about his increased mental distress.
Here's the drawing.
You'll learn that after the meeting, when they left, they didn't embrace him. You'll learn that their home is just down the road from the Oxford High School. They didn't stop by the house to look for the gun. You'll learn never once did they ask their son, where's the gun? They did nothing. They didn't do any number of tragically small and easy things that would have prevented all this from happening. One thing will present itself during this trial is just how senseless November 30th was. And that's because of all of the easy, ordinary things for someone to do that nobody did. What I just outlined to you is a snapshot of the evidence that we presented in this case. You will hear the facts and the evidence from the witnesses. You'll hear from between 20 and 25 of those witnesses. You're going to see over 400 exhibits. You're going to hear from witnesses who were in law enforcement. You're going to hear from individuals who work for Oxford High School. You'll hear from people who knew Jennifer Crumbley in social situations and those who work with Jennifer Crumbley. You're going to hear from victims in this case as well, those who are inside the school November the 30th. You're going to learn a little bit about the scope of the investigation. You'll learn that during this trial, the defendant's cell phone, her husband's cell phone, and their son's cell phone were seized. They were all forensically analyzed. Through all of that data received, in addition to data obtained through cell phone towers, social media search warrants, through information received through banking records,
Could be an overload
GPS
of
pings,
evidence that's not
through
relevant.
gun ranges. All this information will be presented to you, and you'll be able to obtain a digital footprint of the Crumbley family. And you'll get an idea, you'll get a view into
I don't
the
think
Crumbley
that's
life in the days, the weeks, the months preceding the shooting.
I don't think any
You're
of
also
that
going to
is
learn a
in
little bit about
contention.
the aftermath of the shooting. Specifically, you're going to see a pattern emerge in Jennifer Crumbley
Yeah.
after the shooting on November 30th. That pattern will include and show you that she immediately began to downplay and downright lie about her level of knowledge of her son and that weapon and that drawing on November the 30th. This pattern will continue up until the time that she and her husband are found hiding from the police in Detroit. This pattern will show you that her first instinct was to lie, her second was to run. Now, the evidence will show you
running
that
thing
she
is
didn't pull the
bullshit.
trigger, but she's responsible. But there is no claim that she gifted that firearm to her son knowing he was going to commit the attack. There's no claim that she wanted him to commit the attack. So how can she be held responsible when her son pulled the trigger? And the answer is, she's not charged with murder. She's charged with involuntary manslaughter. You see, murder it's an intentional killing. Involuntary manslaughter, by definition, is unintentional. It's rooted in negligence. You've heard Judge Matthews tell you that every crime is made with something called elements. This is no exception. You're going to learn that involuntary manslaughter is committed when someone's acts or their failures to act or their failures to perform their legal duty were grossly negligent, and that gross negligence was a cause of death. A cause of death, not the cause of death. And that's very important because, as you've heard, and you'll hear again and again in this trial, that in a case such as this, when somebody else was a cause of death, the person who was grossly negligent can and still will be held responsible. That is, if the person who pulled the trigger, if the shooter in this case, his act was reasonably foreseeable to the defendant.
15 years is the max.
To the defendant, specific to her, not to everybody else in the world, not to a stranger, not to a teacher, but to his mother, one of the two people in the world who raised him, who lived with him for 15 years, one of the two people in the world who had all the information necessary to put that drawing into context. So what's gross negligence? You will learn that it is a willful disregard of danger.
Yeah, 15
Gross
years each,
negligence
but we have
is when you
concurrent
could use
sentencing.
ordinary care, just ordinary care, to avoid a known danger, and you don't, even though it is apparent that serious injury could occur. And that's what this case is about. It's about Jennifer Crumbley's willful disregard of the danger that she knew of. That's why we're here. We're not here to talk about good parenting or bad parenting. It's not illegal to be a bad parent. We're not here to
You
put
said it.
restrictions on gun owners. That's not our job. That's not your job. That's for lawmakers. We're not here to talk about who else might be culpable or who else you think shares some blame. You will learn about the meeting on November the 30th. You may not like the fact that neither the school counselor nor the dean of students searched the school shooter's backpack. That's okay. That's okay. Because that does not mitigate Jennifer Crumbley's culpability. You're going to learn a whole lot about James Crumbley and her son. But James, he's not on trial today. He has another trial in front of another jury. Their son, his case is over. He's already been charged and convicted and sentenced for terrorism causing death and first-degree murder. Today is Jennifer's turn to stand trial, and you will evaluate the evidence as it pertains to her and her own life. We're here because when Jennifer looked at this drawing, she didn't look at it the way a stranger would. When she looked at this drawing, she looked at it knowing the context and the origin. And when someone with that kind of information looks at this, the unimaginable becomes predictable. It becomes reasonably foreseeable. That's why, even though she didn't pull the trigger on November the 30th, she's responsible for those deaths. I ask that during this trial, you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict.
Yeah, that's what the
If you
prosecutor
do that,
wants her to be able to
You
do.
will find this defendant guilty as charged. Thank you.
All right. Let's hear what the defense says.
I would, thank you. Your Honor, is it okay if I just move this?
Oh, you can move anything you want, there's a lot of stuff. There's cords and stuff. so
I'm sorry,
don't
Sean, can
rush.
you just help me? I'm gonna pull it just forward,
Rush this through quickly.
and I'm gonna keep it to the side, because I don't need it.
Okay.
I just have a few notes.
Sure.
Michigan is known for their short openings. I will say that. We tend not to go very long.
What's wrong?
Just in general.
Sorry, Judge, just trying to get this. Okay.
She has some really good attorneys. Miss Smith here is really good. See what I say about Jennifer looking like a grandmother these days?
On my way to court today, I blasted Taylor Swift to warm up my voice and calm my nerves.
She's a Swiftie.
And there was a line in one of her songs that summarized what this case is about. Band-Aids don't stop bullet holes. And that's what this case is about. It's about the prosecution attempting to put a Band-Aid on problems that can't be fixed with a Band-Aid. The prosecution has charged Jennifer Crumbley with involuntary manslaughter in an effort to make the community feel better, in an effort to make people feel like someone is being held responsible, in an effort to send a message to gun owners, and none of those problems will be solved by charging Jennifer Crumbley with involuntary manslaughter. It's the same effect as when your child comes to you with a boo-boo and you give them a Band-Aid that they put on that doesn't take away the pain and can't undo what's happened to them. And in this case, a Band-Aid will never bring back the lives that were lost by Hannah, Justin, Tate, and Madison Baldwin. And the evidence in this case is absolutely horrific. Much of the evidence is going to make you sick and disgusted and scare you, traumatize you, and quite frankly, there's no reason the evidence needs to be shown. Mrs. Crumbley, myself, everyone in this courtroom agrees that on November 30th, 2021, the worst possible thing happened when Ethan Crumbley used a gun and terrorized the Oxford High School. So as you are watching the evidence, I ask you to keep in mind that much of what the prosecution is going to show you is going to alarm you and disgust you and be horrifically sad and tragic. But that evidence is about about the shooter. And in this case, we have agreed to call Jennifer Crumbley's son the shooter because he is the shooter and he is the one, as you will see from the evidence, who was responsible for the tragedy that unfolded on November 30th of 2021. Prior to November 30th, Jennifer Crumbley was the mother to a 15-year-old son, and she did not have it on her radar in any way that there was any mental disturbance, that her son would ever take a gun into a school, that her son would ever shoot people. The evidence at trial is going to show you that Jennifer Crumbley did the best she could as a mother to a child who grew up into a teenager and had no way to know what was going to happen. Jennifer Crumbley raised a son that she took to soccer practice, basketball, bowling. She's the kind of mother who, when a mole on his back changed color, a 1 millimeter mole, she took him to urgent care. She's the kind of mother who's texting her husband, who is at home, working from home. Where is Ethan? Where is Ethan? Where is Ethan? At 3:14 in the afternoon, getting texts back saying, Ethan gets home at 3:16, what's your problem? And she keeps texting, where is he? Where is he? You will see that if anything, Jennifer Crumbley was a hypervigilant mother who cared more about her son than anything in the world. Jennifer Crumbley is not a perfect parent, and we don't claim that she is. But what the evidence is going to show in this case is that the prosecution has very selectively pulled out slivers of evidence from a forest of trees to try to convince you that there was something wrong with Ethan, and Jennifer Crumbley, as his mom, should have known. And at the end of the day, these slivers of evidence that are going to be presented to you will have no context and no explanation, and the defense will agree that on their face it looks bad. But like any of you who look back at text messages sent a year ago, they may look bad without context and explanation. And so we would ask that you reserve any judgment on these slivers of evidence until the defense presents evidence itself, and we will be presenting evidence in this case to show the context and what was truly happening on these days that the prosecution is going to try to make you believe something more was happening. By way of example, the prosecution has one day where they claim Ethan needed help and Jennifer Crumbley was out with her horse. James Crumbley was with her at the barn. They had just gotten a new horse. Ethan is 15 years old at home, claiming there's a demon in the house, there's something going on, and the prosecution is going to try to use this one little point in time to convince you that Jennifer Crumbley was somehow neglecting her son. Much of the evidence in this trial is also going to center around James Crumbley, who is not on trial in this case. He has a separate trial, as Mr. Keese told you. You're going to hear evidence that James Crumbley and Ethan Crumbley liked guns. They had 3 guns, 2 guns that were purchased earlier in 2021, and a gun that was purchased at a Black Friday sale the day after Thanksgiving in 2021. You are going to hear evidence that James and Ethan went to the shooting range often, that James was responsible for storing the guns, and to be quite frank, Jennifer Crumbley didn't know anything about guns. Jennifer Crumbley, you will hear evidence. She went to the shooting range one time with James and the shooter. And she went a second time after the gun was bought. She was attempting to find a way to spend time with her son, who had just lost a dog, his friend had moved away from him. She's trying to find a way to connect to him. But on that day, when Jennifer Crumbley went to the shooting range, you will hear evidence that she didn't even know where the gun was or how to put it in the car. She had her husband prepare the gun to take it to the range. He had hid the gun in the bedroom of their home. The gun had a cable lock, a trigger lock in place. James Crumbley had the key to the trigger lock that kept the gun secure. James Crumbley used the trigger lock key, took the cable lock off, put the gun in the back of Miss Crumbley's car. Mrs. Crumbley simply drove to the gun range. You will see video of their experience at the gun range, and you will see that the shooter is the one showing Mrs. Crumbley how to use the gun at the range. And when they're done at the range, the gun was placed back in the back seat of the car, not back seat, but the back of an SUV. And Jennifer Crumbley drove home, and not being responsible for storing the gun and not even knowing where the gun specifically was placed, Jennifer Crumbley left the gun locked in the trunk, the back part of her SUV. And James Crumbley was responsible for getting the gun out, putting the trigger lock back on, storing the gun, and Mrs. Crumbley had nothing to do with that part of what happened. Over the next couple of days, this is right after Thanksgiving, the family is picking out their Christmas tree, talking about Christmas presents. There was certainly some sadness in the shooter's life, but nothing that would have amounted to any reason to believe he's going to shoot people or commit a school shooting. You will hear testimony that on the day of the shooting, Jennifer Crumbley went to work. She is essentially the breadwinner at this time. Mr. Crumbley was in between jobs. He's about to get a job offer. Mrs. Crumbley is trying to keep the household finances up. She's at work, and she finds out through an email and text message that her son has drawn this alarming drawing the prosecution put on the screen. Jennifer freaks out when she sees the drawing. You will see the text messages that show she's urgently texting her husband, emergency, call me now, and she races out of work and goes to the school. Upon arriving at the school, she meets with Sean Hopkins, the school counselor. She meets with Nick Ejak, the school principal, and she meets with James Crumbley and the shooter. And they are all in a room together where the shooter explains why he has put together this drawing and what the drawing means. The family and the school talk about how a counselor would be a good idea for the shooter to get into some kind of counseling. The meeting is not nearly as severe as Mrs. Crumbley was initially expecting. Trained professionals at the school who evaluate children represent that the shooter is of no risk to anyone, and they allow him to stay in school. The testimony will show this is not a situation where Jennifer Crumbley refused to leave or refused to take her child from the school. She was provided the option of take him home or leave him here. The shooter struggled when they had online school during COVID It
They
caused
can't.
him
They're
great
not allowed to
anxiety
use his
to
name.
miss school, and he wanted to stay that day. The school was fine with it. Mrs. Crumbley did leave the school and left the shooter at the school, not knowing he was going to become the shooter within the next few hours. Jennifer Crumbley, the evidence is going to show you, returns to work, and suddenly there is news that there's an open shooter at Oxford. Jennifer Crumbley, it's not even on her radar that her son would be the one with the gun doing anything. Her immediate concern is that her son may be hurt. As she is driving to the school as fast as she can, she has conversations with her husband and becomes aware that the gun at their house is missing. And in Jennifer Crumbley's mind, and you will hear evidence of this, she believes that perhaps her son has done something stupid, like taken the gun and shot it in the air or done something. She knows he's still alive and believes that it's going to be okay. Whatever's happened, they can cross that bridge. A little bit later, there's more conversations, and Mrs. Crumbley becomes concerned that the shooter is actually attempting suicide. And Jennifer Crumbley texts her son, "Ethan, don't do it." It still has not crossed her mind that he would ever shoot another person. Ultimately, Jennifer and James Crumbley are called to the substation where they learn that their son has become a school shooter and has shot people and that there are fatalities. Jennifer Crumbley will tell you she still could not believe that was true and went into a complete state of shock and despair and stress and not knowing realizing her life and everyone's life was going to change. And her initial comments are about how could her son have ruined so many lives that day. Jennifer Crumbley sees her son at the substation,
I don't know.
and for the first time, when he looks
I
at
don't know if she's
her,
gonna testify.
his eyes looked black. And it was a son she did not recognize.
I don't think
Jennifer
she
Crumbley
should,
and
but she
James
might have to.
Crumbley go back to their house where law enforcement execute a search warrant. Law enforcement takes their cell phones, which the Crumbleys handed over. The Crumbleys have to go and buy burner phones or track phones so they have something to use to be in touch. They begin to realize that there are death threats around their house. People are planning riots around their house, and they cannot be in their home.
This needs to be explained.
Jennifer Crumbley and James Crumbley drive to a hotel where they spend the night. They are trying to figure out what is happening, and all Jennifer can think about are the things she believes she can control, like keeping her job, keeping health insurance, figuring out money, figuring out lawyers, and trying to digest what has just absolutely tragically unfolded. In the days following the event, while the prosecution says the evidence will show Jennifer Crumbley is lying, Jennifer Crumbley is truthfully telling the world she had no idea and finding out that she is about to be charged in this Band-Aid effort by the prosecution with involuntary manslaughter. Jennifer and James Crumbley go to the bank. They're advised by friends and family, and you will hear testimony that their money could all be taken out of their accounts, and they know they need money to be able to live and hire lawyers and figure out what to do. They withdraw all of the money from their bank account. The burner phones they're using, they can't get access to any of their accounts because of this two-part authentication you now have to do. So they go to the Metro PCS store where they buy new telephones that they can actually use to access their social media, their accounts, their contacts, and they end up with multiple cell phones. After that, they work to find lawyers. They don't know what to do. They don't understand what they're being charged with. They're under the stress of knowing their son is gone. And life
Yeah,
will
but the
never be the
parents
same.
didn't know, Phoenix.
Undoubtedly.
There's no evidence that the parents knew
And
at all.
on Friday, December 3rd,
Chain
the
of custody.
Crumbleys find out when a press conference is held that they are being charged with 4 counts of involuntary manslaughter. And at that point, they attempt to try to figure out what to do, where to stay, where to go, what to do. And they ultimately ask a friend if they can stay at his art studio until they know where to go and what to do. They make plans to turn themselves into the court on Saturday morning, because remember, this is late in the day,
They were not
Friday.
running.
Saturday morning at 8:30 when the court opens up and does weekend arraignments. And overnight, the prosecutor's office, the sheriff's department, the fugitive apprehension team, the U.S. Marshals have a statewide search claiming that James Crumbley and Jennifer Crumbley are on the lam. They are running, they are fleeing, they are trying to avoid charges, and it couldn't be any further from the truth. They are at their friend's art studio. They are waiting for instructions, and they are waiting to turn themselves in first thing Saturday morning when arraignments take place at the
Their
court.
attorneys were also talking to the prosecutor's office at this time.
James and Jennifer Crumbley are sleeping on a mattress in the middle of the night. When police locate them, you will hear evidence. They're not really hiding. They're standing outside their car, their vehicle, smoking cigarettes. They're standing outside their car, talking on the telephone.
Yes, there is.
They're
John Gary.
communicating
There's
with
emails.
various people they know. There's absolutely no evidence to suggest that they're fleeing. You will see body camera footage
Thank you
where
for the
when
gifted
police
membership.
come into the art studio to find them dead asleep on this mattress, they are cooperative, they are taken into custody, and they are arrested. The prosecution has grossly misconstrued facts in this case, and I ask that you wait to make any judgment until all of the evidence has been presented and you have seen every detail of it, including Jennifer Crumbley's testimony, and she
I'll get back
is
to that.
going to take the stand
Ooh,
and tell you about her life with her
the defendant
son,
is going to testify.
about the day he became the shooter, and about the day he did something she could have never anticipated or fathomed or predicted.
All right.
She will tell you that when she saw the materials in this case, she learned that her son had not been her son for months, that he had been manipulating her, that he had been hiding things from her, that he had been sending text messages, alarming text messages to other people. You will hear that the school never advised Mrs. Crumbley of problematic issues that if she had heard about, she would have jumped right on top of it. Despite the fact, the evidence will show that Mrs. Crumbley is on power schools, managing missing assignments by her son and his grades.
Not
The
like
school
this.
never
Jody.
told her about times the shooter was trying to sleep in class, about a test he had failed, about the shooter being called to the office. She was never informed. You will hear testimony. She was never informed that The shooter wrote an autobiographical get to know you poster where he says he feels terrible and his family's a mistake. The school never notified Mrs. Crumbley of this. You will hear testimony that the school never notified Mrs. Crumbley that the shooter was having a, quote, rough time
Nicholas,
when
put
he
the
spoke to
50
the
Swedish
school
krona.
counselor. You will hear testimony that the school never.
I'm sorry, I got to read this. Lots of kids do cruel things. Few become killers. Most become politicians, taxidermists, and morticians. Yes, thank you very much for the 50 Swedish krona.
Notified Miss Crumbley that previous work found in the shooter's files showed that it leaned a little bit towards the violent side. You will hear testimony that the school never told Mrs. Crumbley about an index card the shooter wrote in class that had odd responses with a drawing of a loaded gun magazine and a person
No, the court
holding
said
it
no,
out.
Fem Natel.
You will hear that Mrs. Crumbley was never told much of the information the school had. And so when the prosecution is urging you not to assign fault to anyone else, at the end of the day, we ask that you pay attention to the evidence that Mrs. Crumbley knew. And quite frankly, when you evaluate that evidence and know what she knew and what she didn't know, and learn the context behind the slivers of evidence this prosecution's presenting,
Slivers of evidence
you
in a
will see
forest.
that this was absolutely not foreseeable. This was absolutely not expected. And I am going to ask that you find Jennifer Crumbley not guilty of involuntary manslaughter.
Thank you, Ms. Smith.
All right. I put a new poll up just now. Who made more of a compelling opening statement?
I knew I should have given. Okay, so, can you take like a 10-minute break and then we'll hear the first one? Okay.
All right, for the jury.
10-minute break. And then that. Okay, let me see if I can go through some of these messages that I missed. Nicholas gifted 10 memberships. They went to Emily, Suzanne, Perry, Becca Lynn, Mr. Beckany, I guess, and Paralegal Liz. Paralegal Liz is now a member thanks to Nicholas. Thank you very much, Nicholas, for the gifted membership. Chain of Custody says, hello, at work and lurking. Well, welcome.
Your Honor, I need to run to the bathroom. Do you need to go to the bathroom? She's okay unless the deputies, I think they need.
I'm absolutely streaming this entire trial, every minute of it. And I was supposed to have my cameras in the courtroom, but the judge said no and gave it to WXYZ, and that's the feed we're watching.
Oh, no, I want to interrupt. Oh, yeah, I want her to be comfortable, so whatever she needs.
I can actually, I got a new feed, so I can pause this one. I just wasn't doing it because I didn't want to get behind in the opening statements. I wanted to keep as current as possible.
She does not need to use the restroom.
Okay, it's up to you.
The other one I couldn't pause. This one I can.
You had a taser and gun, so I'm not. It's a lot of people.
Your Honor, what time are we planning to be back?
Just like by.
I'm shocked that that they've already said that the defendant is going to testify. Who made a more compelling opening statement is the new poll that's up. If you guys want to vote, only 75 of you have voted. There's 311 watching. Welcome, everybody. And if you guys have any questions, try to throw a red question mark in the chat so I can see it. I'll try to get to it and answer it. And if I missed your question, throw it in again. Because I don't see them all. And then when I remember, oh yeah, I wanted to ask that question and then I can't find it again. So just keep throwing it in. I'll eventually get to it. But like I said, Jennifer looks a lot older. Like 2 years in jail aged her about 10 years. And she looks like a grandmother, really. I'm gonna bump the speed up 1.5 while we're on a break just to see if we the judge is gone, everyone's gone. I don't know what the court cameraman's gonna do.
Can you let them in around the backside, please? The prosecutors.
I'll keep the mic open and the feed up just in case something happens. Yeah, I don't feel like they should be in jail either. They're not the ones that pulled the trigger. They're not the ones that they didn't orchestrate this. It's not like a Charlie Manson sort of thing where go do my bidding for me.
Seems to be good.
I don't think they should be in jail pending this outcome. Let's see. Why show your hand about her testifying so early? No. Maybe just to prevent the jury from forming an opinion. Everything that they take in from the state side is now going to be consumed with the idea that, well, we haven't heard from Jennifer and she's going to testify. So I'm going to reserve until I hear what she has to say. Maybe that's it. Yeah, she absolutely is going through the worst time of her life. And I don't blame her for aging prematurely. You know, they say that about presidents too. Like presidents go in with dark hair and youthful skin, and then they come out gray and haggard after 4 years. Let's see. David, are they able to speak to Ethan, the parents? Are the parents able to speak to Ethan? No. Parents aren't able to speak to each other or Ethan. They have not been able to speak to each other. They're both in custody, and the Oakland County Jail does not facilitate inmate-to-inmate communication. So, nope, they are not. Are the chains really needed? No, I don't think so. The chains aren't needed. She shouldn't be in custody, but she is. Let's see. If you don't know what your daughter was doing, it was on me. If you don't know what your daughter is doing, if I don't know what my daughter's doing, it's on me. Yeah. No, I don't agree with that. These kids are going to lie. We spent 3.5 or 4 hours watching a child and a mother's police interview in connection with the Zachariah Anderson case last night, where a child absolutely manipulated both parents and the situation. I'm going to tell you this. You don't know what I know. Let me call this and do this. And it's extremely easy for a child to lie and to cover up things. I mean, we spent 4 hours watching it. Yeah, I mean, you could helicopter parent. Okay, well, let me go back for a second because this is interesting. So they added 2 new chairs. Okay, so if you see these chairs right here, these are 2 new added jury seats, and they're right up on. So this is the witness stand right here. So there's a little monitor for the witness. There's a monitor overhead. You can kind of see the bottom of it here for the jury to see things. But there's a monitor here. This is the witness stand. They're like, these jurors are staring down the witness. That's going to be interesting when we actually have witnesses. We won't obviously be able to see the juror though. Sure. Well, I'm thinking about it from a defense standpoint. You know, if you caught the earlier feed, you could hear Jennifer's attorney talking to her about, remember, we got to keep our emotions in check. That includes you. We don't want you like overly emoting a lot. You know, you want your client to just sit there. If they cry, they're faking it. If they smile, they're not taking it seriously. You want your client to just sit there. And ideally, you want your client to behave in a way that each and every juror will interpret as innocence, whatever that is, right? So, but you don't know. So you want your client to basically just kind of sit there. And the attorney was addressing that with Jennifer. You know, you look fine, just be calm, don't emote too much. And so I'm looking at this the same way as a criminal defense attorney when I talk about how Jennifer looks. Let's see. Then if your kid totally blindsides you on something, you could stand up in court and say, yes, I accept these charges, right? Yeah. Speaking of which, my daughter's just leaving the house. Where is she going? I don't know. What is she doing? I don't know. Who's driving her? I don't know. Sorry, David, I missed the start, so can't vote in latest poll. That's okay. That's okay. So far, the defense is winning at 74% in our latest poll, which is who made a more compelling opening statement, the prosecution or defense? The prosecution was definitely concise, but I'm not sure the defense was the best opening statement, to be honest. It was a little meandering. It was a little disjointed. Didn't hit on the elements. Argued more of the feelings than the elements. My whole thing is causation. You can't argue, but you can't argue for the jury to disregard the law. But you can argue to the elements of the law, which is causation.
I wrote last night because I knew she was asking me about it, and I was like, I don't remember where that was.
That's true. That's true. You don't want to promise things in an opening statement that you can't deliver on. That's fair. But I have a feeling if she's saying that she's testifying, she's going to testify. They've thought this through. They've had a long time to think out who's going to testify and say what. I have a trial coming up in February, might go in February. I know right now, sitting here today, who absolutely is going to testify and who absolutely is not going to testify. At least the people that I call. I can smell the air of the witness. Yeah, it's pretty damn close, isn't it? Yeah, there's someone in front of you. You keep talking about how fat and old she looks. Nice try. No, I am saying she's fat and old. She looks like a little old grandma. That's what I admit. I put it out on Twitter, and I talked about it on my jury selection update stream. She is fat and old compared to this look, which was taken a year before, and this, which is her mugshot. Right? She's fat and old now. I'm saying it plays better, in my opinion. Turn on the tracker. Oh my God, turn on the tracker. What tracker? Yeah, we already talked about that. What tracker? All right, I'm skipping a bunch because I'm so far behind in chat. Yeah, you could tell she's really nervous. Thank you all for joining. We will be back to court momentarily.
I don't know what's wrong with me, why I can't find this, but I had it last night.
Yeah.
You know the tracker. I don't know the tracker. What's the tracker?
I already know I will worry about this because it's gonna be.
There's a lot of downtime in court, people.
Oh, here, this is it.
What's interesting too is the state intended to produce an expert that was going to testify to a pathway to violence and testify about leakage, that Ethan Crumbley was leaking his plans and that the parents should have caught on this and that this was preventable. But then when pressed by the on the issue, particularly by the judge, was unable to sustain the argument that you could predict mass shootings or school shootings. And in fact, when experts that were trained in the field were given a test to run through these things, 15% passed, something stupid like that, and essentially 50% or more than 50% failed on predicting future violence. It was a weird sort of test. They would show them images similar to this, and be like, "Is this threatening?" And most of them were like, "No, that's not threatening." When in fact it was like an image taken from a future shooter, and so essentially the judge concluded that it was junk science, that you can't predict these sort of things, and I'm not going to allow you to call your witness, state. And so that witness is not coming in. She performed an excellent, let's see. She has performed an excellent opening statement. She showed context regarding their text. Yeah, see, that's the thing, is there is no context. And if you can't get Ethan on the stand because he's going to plead the fifth, you kind of have to call Jennifer, right? That was why I was thinking you got to kind of call Jennifer. Well, they did, actually. They tried to sue the counselor and the schools, but they was dismissed for government immunity, Aaron. And this isn't even a mass shooting. Yeah, it's a 9mm 6 hour, just a semi-automatic handgun. He was very leaky. Yeah. Miss Smith is the defense attorney, the bearded gentleman. I chit-chatted with him on Tuesday, but I can't remember his name. I don't know. You hate to see it, but it's her case. I can't imagine there's going to be a lot of throwing the husband under the bus. That was a question. And for those of you who are just listening and not watching, I'll try to read out the questions. As a mother of 5, I parent them all a little different because they are different. Some I track, some I don't have to. If I'm aware of something, I creep in. You do the best you can. Exactly, but that doesn't mean, Aaron Olivia, that your kids can sometimes, and probably do quite often, sneak things past you. If you know is the key here, Jen. If you know. Do you know that your dog is going to take a loaded firearm to a school and shoot up people? Ethan's going to be on the stand. Yeah, well, and there's a question as to whether or not that's going to take place in front of the jury, right? So if the state calls him and he's pleading the fifth, is that going to take place in front of the jury? As a defense attorney, I would want that to take place in front of the jury. Ethan's been named as a witness. They're not allowed to say his name, but he filed a notice Monday morning with the court with his new attorneys that he intends to take the fifth and not testify because they're working on an appeal of his life sentence without parole. So because according to the notice, that could potentially jeopardize a future sentencing, him testifying here, he's taking the fifth. Now, I don't know if that's been retracted or not. There was a motion by defense to compel Ethan to testify, but also there was an issue raised that if he doesn't testify, can the state use his journals and text messages? Because the state or the defense can't cross-examine those documents without even Ethan testifying. So, yeah. So it's still up in the air. He's a named witness. Everyone intends to call him, but he filed a notice of his intent to plead the fifth. So who knows if he's going to actually get called. Let's see. Because Ethan is appealing his case. That's exactly right. Yeah. Sorry, I'm a little behind. In Michigan, can you refuse to testify against your spouse? Not really. It's pretty much all done away with in Michigan. But they're not going to testify against each other either because it would be incriminating themselves. Ethan is going to throw his parents under the bus. I don't think it's about that. Ethan's statements during his sentencing was very much in his parents' favor. Parents had nothing to do with this. They didn't know. It was all me. I do have that in my playlist as well. You can watch Ethan's sentencing, and he does make a statement.
Okay.
No, they're talking about her clothing. Megan was there earlier, but she's been asked to move. I guess she's a witness. She was there during jury selection. She's a witness. See, I'm not just saying it to be mean. She really has gained weight. Her hair is gray. Honestly, I thought she was a witness for the state, Salvador. It turns out she's on, or for the defense, it turns out she's on the state's witness list.
All right, court is now in session.
Very weird. Oh, what's going on here? Now we're back. The feed went wonky.
They always go away. I have no idea. Do you want me to go? I'll go grab
The
it.
deputies.
Okay. They keep running away. I'm not gonna.
Shame
worry about it.
on Michigan? Why?
Maybe.
They're coming down the hall.
She's been in trial. Yeah, she's been in jail
It's okay
for
if we just like stay.
2 years.
I don't
Over
like
2
to go on
years.
breaks, but I don't want to, make them sit there for hours on end if they're uncomfortable, so.
We don't have a room, so we're like happy here.
We offered to find you one.
Yeah, we're happy here.
Okay.
We're happy. We're good. You did offer, thank you.
Are you ready? Yeah, okay.
Take those shackles off before you bring the jury in. A lot of officers there. Oh, I don't know if I said this live on stream, but outside the courtroom, not just the courthouse, but the courtroom, if you leave and you go out of sight of the deputies that are in the hallway, you come back, they wand you with metal detectors outside the courtroom. Even the attorneys, everyone gets wanded. So this is her third day and her third outfit. So I imagine they have a bunch of outfits lined up.
All rise for the jury.
Oh, hair color. No, probably not. I don't know if you. Why do you want hair color? What's wrong with gray, John? It's a high-profile case. That's why.
It's probably late to tell you this, but there's a little step there. I found that out the hard way in the dark the first time I came here, so be careful. All right, maybe see you.
I don't know. They do.
Your Honor, calling people versus Jennifer Crumbley, case number 222799990 FH.
Thank you, Marquise. On behalf of people, Karen McDonald is here as well.
And thank you, I'm Shannon Smith on behalf of Jennifer Crumbley.
Sean Godwin.
Who's the first witness?
Molly Darnell. Ms. McDonald is reviewed from the hall.
Your Honor, just before,
If I got the name right.
I'll just hold on.
I'm sorry?
There's one exhibit that the prosecution is going to introduce that I'm going to object to. I just want to let the court know.
Do you know what number it is?
I do. It is number 7.
Are you stipulating to the admission of the other ones or not?
Yes.
I know we were gonna talk about this.
Yes. Yes, I believe that Ms. Darnell is exhibits 5, 6, and 8, and we have no objection to those. 7 we do. And I believe that's already been a ruling by the court. I just have to continue my objection.
Okay, so this was ruled on previously?
Yes.
Correct.
All right, so 7 was already admitted in the written opinion?
It was, Judge.
Okay,
I just have to maintain my objection.
sure.
Thank
This
you.
little thing is bugging
For the
me.
record, that is a portion of the Oxford High School surveillance footage.
And for the record, we just think it's not necessary.
All right. Can you step forward?
Yeah, there was a motion filed to exclude this earlier. The judge made a ruling on it, but they still preserved their objection.
Apologies. Could you raise your right hand? You swear or affirm the testimony you're about to give is the truth, so help you God?
Yes.
Okay, you can be seated.
I'm not answering that question, Mama
Can you
Soros
state
Rex.
your name for the record, spell your first and last name?
My name is Molly Darnell, MOLLY, DARNELL.
Go ahead, prosecutor.
Good morning.
Good morning.
I'm going to call you Molly. I assume that's okay.
That's okay.
Okay. Molly, can you tell the jury what your profession is?
I'm an educator.
Where is it? Are you a teacher?
Teacher?
I am a teacher.
Okay.
I can
And
say teacher.
who is your employer?
Oxford Schools.
Okay. How long have you been in, how long have you worked for Oxford Schools?
I started working for Oxford in the fall of '98.
Okay. Would that be your entire career?
That is my entire career.
Okay. And you stayed in that one school district?
Correct.
Okay. Your current position is what?
I work for Oxford Virtual Academy.
All right. And when did you begin that position?
I began that position 18 months ago.
I'm going to take you back to
No idea who this
November
woman
30th
is.
of 2021. Can you tell the jury what your position was at that time?
At that time in Oxford, I was under teacher contract, but I was the ELA coach and the International Baccalaureate Coordinator. So I worked specifically with curriculum and teachers, like instructional moves in the classroom.
Okay.
You
So,
said ELA, what's ELA?
I'm sorry, thank you. It's English Language Arts.
all right. Thanks, Judge. So how much contact did you have with students compared to teachers at that point?
I would say minimal in comparison to teachers.
All right. And you did go spend some time in the classroom in your career?
Absolutely, yes. I spent the majority of my career in the classroom.
So on that day, what was your typical day like around that time in that position?
So in that position, I would work with building kind of professional development opportunities, or I was working with teachers individually. On that day in particular, I was working with the media specialist and my other coaching colleagues, my other instructional coaching colleagues on building professional development for the next day.
All right. Did you have a classroom?
I had an office that I shared with 2 other individuals, and it was like half a classroom, but it was in the educational hallway.
So it was a classroom made into 2 offices?
Mhm.
Okay. Can you tell the jury when classes began that morning? What was the schedule of the day? Began and end, if you remember.
So you're referring to like the start day of the school
Yes.
day? The school day started around 7:30 and ended around 3 o'clock.
And I know Oxford had a different, they didn't have exactly the same schedule every day.
Yeah, we had a rotating 7, so we met 6 days a week. We met 6 classes a day. But we had 7 classes, so the students only were there in every single class for 4 hours
All right.
a week.
Can you tell the jury what passing time is?
Passing time was about, Oxford's one of the larger high schools in the state. It's the largest single floor high school in the state, I think, at the time.
Do
And
you
so
know how many students?
I off the top of my head, I don't.
Okay.
And so there were about 8 minutes between passing times. Or
That's a
between
good
passing.
question. I don't know if he's
All
there
right.
or she, rather.
November
I haven't
30th,
seen her.
2021, were there any COVID protocols still in place?
Yes, we were still in masks at that point in time, yes.
And were lockers being used?
Lockers were not being used.
Okay, so how were the kids getting their things from class to class?
They were carrying book bags.
I'm going to show you what's been marked as people's proposed Exhibit 5. I don't believe there's an objection, Your Honor.
That's
When I-
correct, Your Honor.
When I say I'm going to show you, it's going to be on this screen and this screen. Okay, Molly, what is that?
Well, let's go.
That's the layout of the high school.
All right, so that's a map of the school.
Correct.
Okay, and can you tell me where your classroom / office was?
So if you're looking at that yellow portion, I am, thank you. I am where you see 222, and then there's 226. I'm that little sliver right in between there, and that was 224.
Okay, Mark's going to show you
Yep.
on the map. He's
Correct.
not letting me have access to the clicker for the
Yeah.
trial, so you're relying on him. Okay, so is that your classroom?
Yes, that like little sliver where you can see, it looks like a bunch of names are written in there.
Mm-hmm.
That was the room that I was in, yes.
Okay, and I'm going to take you to around the time of about 12:50.
Okay.
What were you doing during that time?
So on that day, the year prior, I was in the classroom, and I had a student who popped by around that time just to check in and wanted to chat. I had a chat with her. There was, I believe it was the beginning of passing that she stopped by. We had a quick little chat.
Was that conversation in your
It was in the
office or in the
office.
hallway?
Yep, it was in the office.
Was the door open or closed?
The door was open.
Okay.
We had a little chat. She left. I was alone in the office. And passing was still happening. So I moved to my desk space just to check some emails, check on a couple of things.
Okay. So your desk was in the back of the classroom,
Yeah, it was towards the back side, yes,
facing the door?
facing the door.
Okay.
Correct.
And
I haven't seen her.
did you have a practice of what
Coming
you
out
did
or-
during passing time?
So sometimes I would go out in the hall and check, like just to check and see what was going on, or I might chat with a teacher or two. I didn't on that day because it was towards the end of passing time, and so I knew things would be wrapping up and teachers would be heading back to their classes.
Okay. So at some point, did you see or hear anything unusual?
Yeah, so all of a sudden I could hear a commotion in the hallway, and I looked up from my laptop, and I see a bunch of kids running through the hallway. It was a pack of kids, and they were moving pretty quickly, and there was a commotion around it. I couldn't tell if it was like excited, that it was like higher pitched though. And it was almost like some of the kids' hands were extended, like they were trying to move really quickly.
Okay, for the record, you have both your hands up, shoulder. Okay, and that seemed unusual to you?
It did.
Okay, did it seem unusual because it was at the end of passing time, or just because of the movement and the sound?
It was the movement, it was the sound, it was the large bulk of kids that were moving.
What did you do?
I exited my office. I believe that there was possibly a fight. So I run out of my office. I'm about midway through where 222 is. And I see all those kids exiting out of door 4. So I know there's not a fight.
So if you look at the map, you come out of your classroom and you look down the hallway and they're all running out of the school?
Yeah, on a door 4.
Okay, and that was unusual,
Mm-hmm.
is that correct?
Yes, I had never seen that before.
All right. And then what happened?
I paused for a second because I'm thinking like, well, what's going on, right? I don't know what's happening. I head back into my office space. The hallway is completely clear. And I walk into my office and I'm like, all right, what could possibly be happening in this moment?
Was it unusual for the hallway to be completely clear?
I don't believe the bell had rung yet, so that was
Aaron
unusual.
Olivia, I don't remember her name.
And so what did you do?
It was in pausing, trying to like gather what to do next. I heard 3 things pretty quickly together, like so quickly together that I have a hard time distinguishing what came first and what came last. But there were the sounds of like 3 like loud pops that I could have mistaken for lockers closing if we were using lockers.
Okay. So when you heard the 3 pops, what did you think that sound was?
Well, again, there was doors started slamming. I could hear like boom, 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 boom. And then the principal at the time, Steve Wolf, came over the PA and said, we're heading into lockdown. This is not a drill.
And how long had you known Steve?
So a couple years at that point in time.
Okay. Did his voice sound panicked?
His voice sounded, it was like urgent, but you could tell he was like tempering any, like panic.
So was that before the loud pops or after, if you can remember?
Honestly, I cannot remember.
Okay. When you heard this, was your door open or closed?
My door, when I came back in, I pulled it, but it didn't shut. So it was open a couple inches.
Okay. So what did you do?
At that point in time, I moved to shut my door.
Okay. After the pop, did you smell anything?
No.
Did you see anything?
No.
All right. Then you tell the jury what happened when you turned around and headed to the door.
So I walked to the door. I immediately pull it shut. To the left of my door. So my door was here and there was a glass part, like, floor to ceiling glass. And then right here was a night lock system.
Can you tell the jury what a night lock system is?
So a night lock is a simple gadget that goes into the door, that goes into the floor, so that if the door were unlocked, it's like a second security measure. If the door was not locked, or even if it was, someone can't get in. So if the glass is shut out, even if they're trying to undo the door, they can't open the door.
And when did you learn about night locks?
The defense
maybe
has already
4 years
argued
prior.
this in a motion, pretrial
Did you do
motion,
that?
and lost.
Why did you install the night lock?
Well,
And
one, I was directed that we're in lockdown, right? So
the
as soon as
defense
I knew that
also-
we're in lockdown, that's what you do.
Placed it on the record.
Were you able to install the night lock?
So I grabbed the night lock, I undid the piece, grabbed it, and looked down at it. So I also, some of the doors have different installs, whether the door goes, in or out from the room. And so I looked at it to see, just to remind myself which one, because the other office that I have at the middle school, or had at the middle school at the time, had a different.
At this point, Molly, the door is shut or closed?
The door is shut.
Are you facing the door or facing
I'm
away?
facing the door, so I'm close enough to that wall because I had just grabbed it.
Do you know about what the distance was between you and that door?
Not even a foot.
Okay. And then what happened?
I look at it, and out of my peripheral vision, I can see some sort of movement. And so I look up, and I see someone dressed in dark, oversized clothing.
And you're looking through that glass
Looking
pane
through that glass
next
pane.
to your door. Okay.
They have the mask on, a hat, glasses, and a hood. And I lock eyes with them.
Had you ever seen that person before?
I had not, no.
Did you know if it was a student or is that a no?
I did not know if it was a student.
All right. And you said you locked eyes?
I locked eyes. And then instantly I noticed, I see that some movement. And so I looked down and I realized he's raising a gun to me.
Okay. Can you describe?
Yeah, the gun was black, and I remember thinking, as he's raising the gun to me, that there was no orange tip. I had heard prior that BB guns have an orange tip.
When you say he was raising the gun, can you explain what that looked like? Was it one arm or two arms?
Well, I just saw the one starting to move up. I saw the gun, and I moved.
Which way did you move?
I moved away from the glass partition, away from the door, toward back into the room.
Okay. You just described you saw something in your peripheral vision.
Okay, to be fair, in order for the prosecution to convict Jennifer Crumbley, they need to first say that a death had occurred and that this whole shooting actually happened. Now the defense concedes to it, but the judge has said, well, the prosecution is still entitled to put forth their proofs. This is one of the elements that needs to be proved, that the shooting actually happened. Even though everyone agrees that it happened, they still have the right to put forth their proofs. So it is relevant. It's unnecessary from a technical standpoint, but the court's allowing it.
You looked up. You locked eyes.
I locked eyes. He didn't hesitate.
Okay. About how long was that from the time you saw the peripheral
It'd be like
vision?
saying the two people
then
conspired to rob a bank.
gun
You need
was
to prove that
raised.
the bank was robbed, right?
A second?
Same sort of idea.
Okay.
If that,
I don't agree with it. I agree
When
with
you locked eyes with this
millionaire.
individual, what did you see?
I'm sorry, can you repeat that question?
Describe that for me.
I lock eyes with him, and I instantly see that movement. And I jump to the side.
What happened after you jumped to the side?
As I jump, I can.
And was did you ever get the night lock installed at that
The
point?
night lock is not installed at this point.
Okay.
So when I move, I kind of jump and turn my body this way at the same time.
Okay, and for the record, you're turning your
Yeah.
shoulders to the right.
To the right.
Mhm.
And I feel like my left shoulder moves
Yes.
back a bit, and I feel a burn like hot water had stung me.
Where did you
Not
feel
this
that?
exact testimony, but
in my-
similar.
Arm,
Which arm?
in my left arm.
Okay.
Up
And you're
top.
pointing to your
Yeah.
right below your shoulder?
Yep.
Okay. And are you standing up? Are you sitting down? Are you?
I'm standing up at this point in time. I feel that hot burn go through my arm, and I turn back. There was a window in the back of my room that leads out to the courtyard, and I see a bullet hole.
Okay, I'm going to show you on the screen what's been marked as People's Proposed Exhibit 6.
Objection. 6 is removed.
What is that, Molly?
That's the office that I shared.
Okay, and that, can you just describe where the desk is, where what you just described and point that out? You said
Yep.
you turned around to the back of the classroom.
Yep. So you can see on that window exiting, there's a white mark.
Right there?
Yep, that would be the bullet hole.
Is that what you noticed when you turned around?
That is what I noticed when I turned around. Correct.
At this point, what were you thinking?
A BB gun can't do that. It seems like really silly.
What seems silly?
that I couldn't wrap my head around what was happening.
I mean, after you felt the warmth and you still were thinking it might be a BB gun.
Yeah.
So what did you do?
Yeah, the defense did stipulate.
Is
to
the
that.
night lock installed at this point?
The night lock's not installed at this point, and the only thing I'm thinking is I have to barricade this door. Like there was instinct that kicked in. So what you can't see is right around that corner, there was this huge filing cabinet.
And I think if we can point, so to the, around that corner to.
Yeah.
Okay.
And
There's no
so
cross
I
of this
grab it
witness.
because I'm afraid to go back towards the door
There
at this
shouldn't
point
be
in
any
time.
cross.
And I try to move it,
Unless she says
thinking
something
maybe I can pull
specifically
it out
about
enough
Jennifer.
and push it. And it was just too heavy for me.
I wouldn't cross
So
this
that
line.
rolling cart was sitting next to it. That's when I pulled out the rolling cart and no, sorry, I take that back.
It's
I didn't
okay.
do that yet.
Take your time.
I crawled down on my hands and knees and I put that night lock in. And then I moved for the roll. I was like, I just have to keep barricading. I just have to keep barricading. And so I grabbed the rolling cart.
Is the object in the,
Yeah, you can see it's the little red object on the rolling cart. Yep.
oh, that's the night lock.
Yes.
Okay, but that, it's sitting on that's the rolling cart, right?
Correct.
All right, and were you able to put it in front of the door?
I was able to put the rolling cart in front of the door. Correct.
Okay, and then what?
I have faith in the defense
Then
attorney.
the only thing I
I
can
don't think
think
she's
of
gonna
is
cross.
he's going to come back and finish what he wanted to do.
Could you hear anything else in the hallway?
At this point, I'm not hearing anything.
Okay. And so what did you do?
There might
So
be
I
minimal
continue, I go
cross.
back to that large cabinet because I know if I'm anywhere in the back of this room, he can see. So I need to hide in this front corner. And so I pull that,
Do you
that
ever
large
have any
filing cabinet back
meetings?
just enough to crawl behind it so that if he comes to that window, he can't see where I'm at.
Did you ever have any meetings with Ethan, any encounters with Ethan? Did you ever sit down and talk to him about his thoughts or his feelings or talk with his parents? I think that would be the limit of my cross. Basically, she knows nothing else. Establish that and
So
move
the
on.
way the classrooms are is you have to be at a certain angle to see certain parts of the room from the hallway, correct?
Correct.
Okay, and you said you moved to that corner behind because what?
Because I didn't want him to see where I was at.
Okay. Once you were behind the cabinet, were you sitting?
I was crouched down. I was trying to make myself as small as possible. Right. I got really low. I was on my bottom, crouched as close together physically as I could make myself.
Okay. What did you do next?
I had texted my husband, "I love you, active shooter." And then I started feeling blood dripping down my arm.
And what did you do?
Um,
At this point, had you registered that you had been shot?
I don't think I was registering that I was shot. I just knew that I was bleeding.
Okay. What did you do?
I had a cardigan on that day. And so you can see in the photo, there's this red little bag on the side, on the right side of the wall. Those are, those are medical response bags that we keep in every room. So if someone's bleeding or if a tourniquet's needed, they're in there, but I was too afraid to go back and grab it. So at that point, I knew I needed to put a tourniquet on. I knew I was bleeding. I removed my cardigan and I used one of the sleeves of the arm, wrapped it up on top and pulled with one arm and my teeth with the other to tighten it.
And Molly, how many inches down was that wound?
It sits right here.
Okay. And you brought a cardigan so that you could show the
Removed.
jury what that looks like so they know exactly where you were headed?
Yep.
Go ahead.
I don't know if you can all see okay, but
They're absolutely going to show one of the jurors. Oh my God.
Can everyone see? They can see, yeah.
so you can
They're
see it
showing
kind of
the
sits to the
notepad in
back.
the
So when I
hand.
was turned, that was the entrance and the exit.
And there's two holes there.
Yep.
This is why you
so
should have had
entered
my
here
cameras.
and exited here. And the space in between the heat of the bullet cauterized
The skin.
the skin.
Okay. You can sit back down. You put the tourniquet where on your shoulder?
I put it above the wound.
Okay. How'd you know how to do that?
We go through trainings once a year regarding what to do,
Okay.
in the situation.
What
Hey.
happened next?
Thank you very much, Baker Raiders. Welcome, everybody. Welcome. We are on the first witness in the Jennifer Crumbley trial. This is a teacher that was shot by Ethan, the name that shall not be mentioned apparently in this trial. And that's where we are. Relevancy, slim to none, since the defense has stipulated to the fact that there was, in fact, a school shooting that was carried out by the defendant's son. But yet the state has insisted on having this woman testify, reliving this very tragic event. And that's where we are. So we are still on direct. But welcome. Let me know if you guys have any questions.
I put the tourniquet on.
They're going to play the video of the shooting, which is
in my
horrible.
head, I'm thinking, okay, what do I do
They're going to
next?
play it.
What's
That's
like the
Exhibit
next move
7
here?
is coming up.
And my daughter texts me. She
Rose.
didn't go to Oxford High School, but she went to
Thank
a
you.
neighboring
Thank
school
you.
district. And they had heard through social media that there was a shooting at Oxford High School.
Welcome.
And so she sent me a
Kaylee.
message that just said, Mom, are you okay? And I responded to her that I love you. I'm sheltered in place.
I don't know how many are there today.
And
There's
I'm
20 to
fine.
25 total.
You didn't tell her you were.
I did not tell her I was shot, no.
Molly, I want to go back, and I'm so sorry. When
I don't
The
think so,
shooter-
Neo Dark Matter.
raised his hand, what were your what did you notice about, if you noticed anything about his stance, or you said you locked eyes?
Yeah. His feet were set about hip distance apart.
Okay, yeah. So let me give a quick update on this trial. So this is Jennifer Crumbley is on trial. First of all, welcome Keely. And if anyone else is a new member, make sure you click my member tab, which has, just click it ever so gently, has a link to my Discord where I have a lot of member content, including all kinds of stuff about this case, all kinds of filings and everything like that. But Jennifer Crumbley is on trial for involuntary manslaughter because her son intentionally shot up his high school on November 30th of 2021. The state's theory is that they neglected their son and took no due care and were grossly negligent in caring for their son and protecting it, specifically protecting society from a known danger, which was their son. That's the state's theory. I find it to be very dangerous to run with that theory. Mainly because we're not talking about a negligent act by a child who is placed in a position by the parents, such as locking two children that are 7 and 10 in a room with a loaded gun for the entire day. That's not what happened here. This is the intentional wrongful acts of a nearly adult, 15-year-old child, but they're charging the parent. So I'm very concerned about this trial just from a fundamental standpoint, holding parents responsible for the intentional wrongful acts of their children. But that's what we're here for. It is a involuntary manslaughter charge. This is the state's first witness. We just had opening statements earlier this morning, which I felt both sides were fairly good with. Both were good in setting out their positions in this case. The state essentially says that they knew their son had mental health issues. They had just purchased a gun for him and took him to the shooting range, and they should have known, and yet they did nothing to protect society at large. And Mother's Defense Counsel came forward and said basically she didn't know. The last thing on her mind was that her son was going to do this sort of thing. So it's the battle of the parenting skills, essentially. But this is a teacher at the school who was there and was shot, and we'll get back to it.
And that's, he was, and his shoulders were like, he was square, right? He was square.
How long were you in that classroom?
I was in there for about 20 minutes.
Were you communicating with anyone else in the school or
Um,
law enforcement or administration?
No, there were a couple teachers, my hallway had a text thread.
The
that was
judge said
not
that the
active.
state
There was
has
nobody texting on that.
the burden of proof.
But another
Prove
part
each
of the building
element
where the
and can
English
present
language arts
evidence.
department is at,
It is what
they
it
were
is.
texting. And one of them said, I heard there was a shooter. And I responded that I saw one.
Did you respond that I've been shot?
I did not.
Why is that?
I think I didn't want to like create panic. Like I wanted
Yes, she
to
did,
make
Emma.
sure that people knew it was serious, but there's no, like, I'm okay.
Okay. At this point, did you have any idea where the shooter was, if anyone else had been hurt? What were you hearing? Anything?
Nothing. And it was
Yes.
absolute silence for a long time.
I'm gonna speed this up. Just because.
And then I started to hear
It's too
a volume
fast,
of
let me know.
footsteps. And I thought, they must be evacuating a classroom. And so when that shift occurred, I texted the teacher next door and I said, hey, you're the only one that knows right now.
No,
but
has nothing to
I've
do with Parkland.
been shot.
Oxford, Michigan.
I hope I'm the only one.
How long was that? How long were you in the room then?
At that point, it was probably 18 minutes.
Okay. At some point, did somebody ask you to leave the classroom?
Yes. So the teacher next door was like, oh my gosh, I'm calling the office. There was another teacher in the room with her who texted administration.
And at some point, did somebody come to the door?
Yep. So the text from administration, Kurt Noose was at my door within maybe 2 minutes. Time's hard on that. And he was like knocking, Molly, are you in there? I've known Kurt Noose.
Yeah,
since
they're not being
since we
charged
started
with
Manslaughter.
neglecting a child. They're being charged with involuntary
I did
manslaughter.
not trust that was him at my door.
The elements of which are the defendant caused
I
the
don't
death of
know,
another and that death was
Everything
caused
that
by
I knew
gross
to be reality
negligence.
wasn't.
Problem with the causation is that you have an intentional
answered that,
wrongful
but
act
did
of a
you
third
open the door, or
party
did you just
intervening,
I said, I'm in here. And he said, are you okay?
which
I
normally
don't
people aren't
remember how I
responsible for.
responded. It was within a second or two that then there were police at the door and they were like, are you in here? Are you injured? I said, yes.
Good morning, Perpet.
And then I said, do you want me to, it was clear that they wanted me to, like, they were there for me.
And they couldn't just open the door.
They can't just open that door. That night lock prevents them from getting in the door.
And Molly, if you know,
I would say
how
mom's a
would you get
victim
into
too.
that room if someone doesn't remove
Jennifer
the night lock
Crumbley is a
from the
victim of the
inside? Is there a way?
situation.
So I know there's a special tool to use, but you'd have to take everything off that door and that's all steel.
So the frame, actually.
Yes.
Okay. And so they were asking you to remove the night lock. Did you do that?
I said, do you want me to remove the night lock? And they said, yes, remove the night lock. And then I said, do you want me to open the door? And they said, yes, open the door. And I'm down on the ground while I'm doing all of this. Like I'm removing the night lock and I'm opening up the door from my knees. And they like scoop me up.
Oh, Dan, I
And
got
I
your
can
email.
see
Thank
the
you.
two officers that scoop me up, but I can see Kurt standing there against the lockers. And I can see 4 cops with guns.
Did you see any students?
I did not see any students, no.
Okay, Molly, I'm going to play a surveillance, which is marked People's Exhibit 7, which I know there's an objection to.
Yes, there is
the
a
judge
big
previously
objection
ruled.
too.
Just to let the jury know, you're not going to see any victims in this, except for Molly, and nor are you going to see any students.
The state said, or the defense said that this was just purely inflammatory. They did a prejudicial versus probative
When you say you
analysis,
saw 2
and the court
officers with
concluded that it
guns,
was
how
not
far
overly
away were they?
prejudicial.
Were they in the same direction?
They were, so when they scooped me up, the 2 that scooped
Okay,
me
I'm gonna
up,
stop you. Look here.
Yep.
Is that the hallway?
that's the hallway.
Okay.
So you can see there's multiple around, so it wasn't just the 2.
Where's your classroom in this photo?
It's farther down, right? So you can see, yep, like they're going inwards towards the classroom.
Okay,
It looks like that's an officer there.
okay.
So I knew that they were officers based on the vests that they were wearing. And so they're just They were
I
just
slowed it down
around,
again
right,
because of the
as well,
video.
like securing the area, I suppose.
All right, you can press play. Is that you, Molly?
That is me.
That's it. I don't feel like this is overly prejudicial if that's all they're showing is the teacher and some police officers walking down the hallway. Although I suspect the state's going to try to produce more graphic video at some point. Mangs. We all are, but I've addressed it numerous times.
At this point?
The defense objected, the judge allowed it in.
No, everything is silent, like almost like it's so like echoey. It's so silent.
Okay, now you can see through that glass door. Is that you?
That is me.
What's happening?
He's removing the self-made tourniquet from my cardigan, and he's putting on an actual tourniquet.
Okay. And at some point you get into an ambulance, correct?
Yes. So at this point, he says,
I have
I'm on a radio
no idea
to
what
see
the
if
point of
there's
this
an
video
ambulance
is. I
available
would
for
argue
you.
relevancy. It's not even prejudicial. It's relevant.
Making sure that no one else needed it ahead of me.
Okay.
She's a hero.
You eventually get into an ambulance. They take you where?
I
They took me to Lapeer.
don't understand the relevance.
What happened when you got there?
So I get to Lapeer, and the doctor comes out to the ambulance and introduces himself. And they said, I was sitting in the ambulance the entire time, and then they said, we're going to put you on the gurney. And I said, I can walk. Like, if I can walk, I
Well,
want
it's
to walk.
best to get it done early.
And
I
so they
guess.
help me out of the ambulance, and I walk in, and they're like steadying, like kind of almost holding me up, steadying me.
Yeah, but
And the hallways are lined
Brent, it's not time for victim
with
impact
doctors and
statements.
nurses.
Did you see any other victims?
I did not. No,
Okay. And they treated your wound.
they did.
Okay.
This is not sentencing, folks. This is not a victim
Were you
impact
able
statement.
to,
It doesn't matter how it impacted
I
the
assume they
victims.
ran
This
some
is not
testimony.
sentencing.
Cognizant of the judge's
We're going over
prior
guilt or
what you
innocence of
testified to.
Jennifer
But,
Crumbley. This
at
has
what
no
point-
bearing
How
on
long were
that,
you at the hospital?
other than the fact that
I have no
a
idea what
shooting
time I walked in
happened.
those doors.
A shooting happened. That's the element.
I was there for
Needs to
several
be done.
hours.
Did you learn at some point there were other victims?
I did ask when I was in the hospital, is anybody else been injured? And I was, I was told that there were other victims and a few fatalities. Yes,
Okay. At some point, did you hear a teacher was shot?
I did.
And what did you think?
I instantly thought it was another one of my colleagues. I knew the direction that I saw him turn, so I knew what direction it came.
And who was the teacher? Mom?
I thought it was Lauren Jasinski.
It's not what
that
you
was shot.
said, Brent.
But who was the teacher they referred to?
It was me.
At some point, you were shown weeks later a picture of your doorway. Do you remember that?
I do.
Okay. Do you remember
Yes.
who showed that to you?
Let's stipulate that.
No,
Okay. Was it me?
I did. Well, I did see. I did see it in your office. Yes.
Okay. And you were preparing to testify.
Yes.
I'm going to put that picture on the screen. It's People's Exhibit 8. I don't think there's an objection. Molly, is that your classroom door?
That is my. Yes.
What was your reaction when you saw that?
He was aiming to kill me.
Do you know which one of those shots landed in your shoulder?
I don't. I have no idea which one landed on my shoulder, but I know the top one. That's where my head would have been, and the two down below are my chest area.
Okay.
I unlock that door every day.
And what was your, did you have some, what is your, when you think about the wound and why you weren't hit, why was it in the chest?
That door, the distance, the door, and me moving was the only reason that I'm alive.
How many inches from your heart was that, that injury to your shoulder?
The actual wound is 6 inches, but my turn might have made it less.
Thank you.
Thank you.
I have nothing further, Your Honor.
There should be minimal cross.
I have no questions. Your
Okay, that was fair.
This one's
That was
easier.
good. No cross.
This up on your-
You don't need to cross this witness.
Christy Gibson Marshall.
Hey, Christy Marshall.
We prepared her, Your Honor. We understand it's not a Miller hearing, we know it's a trial.
Yeah, see, it's not a Miller hearing. It's a trial. This is not a victim impact statement sort of thing. They say Christy Marshall? Was that the name?
The media is guessing whether or not they can videotape the video. I don't see a reason why they can't, right?
No, there's no minors.
Oh, okay, I want to make sure.
The young lady with the glasses in the front row is from Chicago.
In this portion.
Oh, yes, in this portion. We'll indicate which,
Right.
which, videos can be shown.
It's a lot of bailiffs. Yes, it is.
I'm also concerned giving heads up to the jury so everyone's prepared.
And then, Your Honor, again, the defense objects to, I believe it's just one exhibit you're using with Ms. Gibson.
This witness?
I believe it's only exhibit 9.
This was previously extensively briefed.
Yes.
I made it a note of that.
Yeah, but she can still maintain her objection. Judge.
Thank you.
Yeah, they argued about this last week, or 2 weeks ago, rather, a lot of it. Well, there was no argument. The judge issued an opinion based off of the written briefs. Okay.
People call Christy Gibson Marshall.
Good morning. Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God? All right, please be seated and please state your name for the record and spell your first and last name.
Christy Gibson Marshall, KRISTYGIBSON -MARSHALL.
You want to prosecute?
Thank you. Good morning. May I call you Christy?
Yes,
Say Mark
Christy, could
MALL.
you please tell the jury where you're employed?
Oxford Community Schools,
How long have you been with Oxford?
29 years.
And what do you do right now?
I'm an assistant principal
Okay. And that's at the high school?
at the high school,
How long have you been the assistant principal at the high school?
6 years.
And what did you do before that?
I was an elementary principal,
Also in Oxford District?
yes.
Now, if you could tell the jury a little bit about your role as an assistant principal. What are some of your responsibilities?
Teacher
I
supervision.
think I spelled their name right.
Evaluation, curriculum and instruction, supervising, I do parent communications. It's hard to think of all the stuff that my big giant list while I'm sitting here, but we
Now we're right back.
have a student relations team that works together to support our alphabet, part of the alphabet. Big goal is, like, to me, my biggest role is supporting students, and I love the kids, so just bringing energy and having fun with them.
You've been in education, you said, for 29 years?
Yeah, yes,
So up until this role, you were an elementary school principal?
I was, and then prior to that, I was a teacher.
Teacher before that, okay. Now, as it happens, the school that you were principal at was Jennifer Crumbley's son, one of those students.
Yes,
And what grades, if you recall, was he there?
4th and 5th.
Did you have any contact with him in your role as a principal in those 4th and 5th grade years?
No.
Did you have any contact with his mother or father?
Not that I remember. I had an email about a report card once, but that's all I remember.
And that would have been years prior?
Like 5th grade going to 6th.
Now, I'd like to direct your attention to November the 30th of 2021, about 12:50 in the afternoon. So we have the screen in front of you. That should be displaying People's Exhibit 5. This is a map of the Oxford High School.
Yes,
if you could tell us, if you recall, where you were about 12:50 in the afternoon that day.
I was in the I started in the cafeteria supervising lunches. So what would be, I guess, they're the commons.
So right
Yes,
here?
correct.
Okay. So was that lunchtime when you were there?
Yeah,
Okay.
yes.
Yep, they're just
And is
establishing
there a
that
time
a
where you
shooting
moved?
happened.
So around that time on November the 30th, did you have a specific area of the school you would go to, or did you move around?
We didn't have an assigned area, but I like to go to the senior courtyard after lunches and just kind of help see that courtyard area.
Okay.
The hallway out in front of this courtyard area.
Jamie's
between
hanging out
where you
with
see
Baker.
400
It's his custody day today.
401.
Okay.
Our seniors hang out there and they congregate in a good way, not terrible. Let me just clarify. It's kind of like the rite of passage, and we just like to kind of go there and keep traffic flowing.
Okay.
Yeah.
Is that something you would do on a routine basis?
Yeah. My bad mom joke on that one is that I make it a senior citizen window and I stand in that area.
Was there a point that day when you realized something was going wrong?
When I was approaching the senior courtyard, so when I was coming down the hallway from the commons, what says commons, I call it cafeteria, by the media center, by the courtyard,
Weird.
and hit the 500 room. When I kind of got to that triangle there, that diamond there, one of the students that I know pretty well went running by and said, "Get the hell out of here." And he was laughing and running, and I was like, that was a mixed message.
Sure. At that point, was there an announcement on the loudspeaker?
No, not at that point, no.
Was he the only one running?
Shortly after him, there was a group of kids laughing and running behind him. When I stopped to ask them what was going on, they weren't entirely sure. But as kids started to pass, you could see it got more serious.
Okay.
I grabbed my walkie-talkie and I
What do you mean it got more serious? What do you mean by that?
their faces got more, I'm sorry, their faces became more serious.
Did that signify something to you when you saw that?
Yeah, just something. Them
Brent, are you
running
just saying
signified
random
something to me, 'cause
things in
it's
the chat?
Not a typical behavior.
Okay.
But the running and laughing was confusing, and then when their faces became more serious, I was started to get very worried, and that's when I grabbed my walkie-talkie.
Okay. What'd you do with your walkie-talkie?
I said, "I'm not sure what's happening, but kids are running in the hallway, which is very odd, and look like they're trying to leave the building."
So where did you go?
Hey, Jamie.
Shortly after I got on
Hi.
the
How are you?
Good. Is my volume
Did
good?
other daddy let you join us for a little bit?
Oh, shut up.
You guys are on
No.
jury watch over on the Treehouse murder case? Or
Yeah,
verdict watch, rather.
it's on verdict watch, so just thought I'd come hang out because I was kind of watching in the background.
Oh, well, welcome. We'll keep going with this principal who's going to tell us all about the shooting, which everyone is stipulated to.
So they were allowed to bring the videos in because I just feel like that's so prejudicial.
Well, those videos didn't show much. I mean, it just shows them walking down the hallway. I
No,
really don't understand.
I didn't get to see the one video. I thought I heard you say they were bringing in the videos of the shooting, and I was like, oof.
That's what it's led to believe based on the filings by the defense that objected to bringing it in, meaning it's more prejudicial than probative, and we're already stipulating that a shooting happened. So,
Yeah.
and while we're at it, chat, Cheraz gifted 5 memberships. You guys get to hear me read the names: Melody, Nicole, Ariel, Westerners, Wrestlers. Wrestler's mom. Oh my God. Aquanet. You got it. And Ace. All right. Thank you very much for the gifted memberships. Much appreciated. If you are a new member, click the member tab on my YouTube channel. It will take you to a link to my Discord where we have all of our member content, including a ton of documents on this case, as well as a bit of everything associated with all the cases that we cover.
They,
Good times.
they went to Alice Alert. And so
What's the Alice Alert?
Alice Alert is it's our intruder, I'm gonna call it an intruder alert because that's what it was that day, but it's a notice that we need to take cover, lock down, be aware. It's
So
an
is that
emergency
An
assistance.
alarm ringing, or is that somebody who's giving a message over the PA system?
On that day, it was a message over PA system.
Do you recall who gave
The
it?
jury won't see
Steve
through it,
Who
Rachel.
was that?
Jury
Steve is our
will
principal.
absorb it all.
So is this shortly after you saw the students leaving that appeared to be more serious to you?
Practically the same, yeah, it was like they went, when the more serious students came by, the announcement went on.
Okay. Now, when you hear that announcement, what were you supposed to do?
Again,
It's
I'm going
supposed
to
to lock
speed
down.
up so we get to live, and I find this redundant. We all
What did
know
you
what
do?
happened. So it's going at 1.25.
I went to check the hallways to make sure people were okay.
When you first started to check the hallways, did you see anybody?
The hallways cleared so fast. When I made the turn down the 400 hallway, I ran into a teacher who was locking his door, and then a student came up who was running late. He asked if it was a grill.
Yes, we do.
I let him know that it
You
didn't
guys want
matter.
to know the
It's a grill,
makeup
not
of the
just
jury?
get it-
Jamie, do you want
get
to?
covered, get in there. And
I
then
do.
I proceeded down the hallway. I was the only one in the hallway at
Okay,
that
she
point.
proceeded down the
Did you hear
hallway, and there's going to be videos. Okay, I'm just turning it down for a
Still
second.
smells
There are
something.
17 jurors total, so there's 5 alternates. 10 women, 7 men, 1 black man. Everyone else is white. They're mostly parents. They have said that they're okay with firearms. Some of them go hunting, and they claim to not have an opinion one way or the other regarding Jennifer until they have heard the evidence. The judge made that abundantly clear, was asking them. It was a back and forth a lot about that stuff. The one witness, who's a veteran firearm owner, is
Did you see anybody else?
fairly okay. I'm concerned about one of her statements where she said, when I think about this case, I get enraged.
Oh,
But
she
apparently
stayed
she's-
on the jury?
She stayed on the jury, yeah.
Oof.
Turned left. to
So,
go towards where I heard the gunshots.
But most of them also agree, or many of them also agreed, that teens can sneak things behind their parents' back. It's almost impossible to catch everything that your kids are doing on their phones. So I'm
I saw
playing,
a
yes,
student
I'm
laying
playing
on
the
the
video in Angry Elf
Did
speed.
you know who he was?
I didn't at that time. His face was covered. And then as I continued a couple of
Again,
steps,
I would
could
not do any
see another
cross on this
student
witness right
walking
now.
my direction. He had just dropped his arm was up and then he dropped his arm.
There are 5
Did you
alternates.
recognize him?
Not at that point, no. He was too far away.
What did you do when you saw the student on the ground?
There was a garbage can between he and I, so I moved the garbage can out of the way. And I put my foot near him and nudged him and told him to stay there.
The judge's Q&A
fine.
of the juries yesterday or Tuesday
Did
was
you tell
really
he was
good.
injured at that point?
You could tell he's injured.
What happened next?
Ethan then came into closer view and I could tell it was Ethan.
He had been at the school where you were principal?
Yes.
Did you interact with him at all at Oxford High School?
Just normal, like how I interact with everybody, high fives, hugs, silly stuff that I do.
Okay.
I brought my elementary to the high school, so I just,
Did you say anything to him?
when he got close enough to me that we were sharing the hallway, so he was kind of walking down the center and I was
I
kind
never
of
want
to the
you on a
side, so
jury, Brent.
that's- We're probably
Sorry.
3 feet apart.
You're too
I,
emotional, man.
Asked him if he's okay. It just didn't seem right that it would be him. He just,
So I need to back up just a little bit. When you didn't know who it was at first, the student down the hallway, you said he had lowered his arm.
I knew it was a shooter when he was down the hallway.
Okay. Could you see if he was holding anything?
I could see it.
At that point, was he walking towards you or away from you?
He's walking towards me. It was when I realized it was Ethan that I didn't think he could possibly be the shooter is what happened. Like I know I said I knew he was a shooter down there because I could rationalize that is a gun. He is putting that gun down. He just shot something.
Okay. Now,
Yeah, unlike other trials that we've watched, the alternates do not know they're alternates. They're selected at random at the end of the trial. So right now, all 17 of them could possibly go back to the jury room. So they all have to pay attention.
And I know this doesn't matter, but I was just, maybe I missed that part, but when Ethan did the shooting, did he actually target anybody or was it just random?
I'm not sure. He's never really spoken about that.
Yeah, I was just, wondered if I missed that part. Okay.
I know this is difficult, but I need you to use your teacher voice and speak.
Okay.
loud and clear.
It's
So I think
because-
coming towards you, how close, how far from him were you when you recognized who it was?
He was probably by the room 220 when I could tell who he was.
Okay.
And I was standing between 226 and that white section there that, yeah. There's exit doors there.
Now, you said you said something to him?
Yeah, it seemed so odd that it was him. So I said, buddy, are you okay? What's going on? And when he didn't respond to me and he looked away, that's when I knew it was him, that he was the shooter.
Did he point the gun at you?
He did not.
What did you do at that point?
I got on the walkie and I told my team that I have eyes on a shooter and I have a victim.
Now this hallway, 200 hallway, there's a curve to it.
Yes.
And he was walking, he followed the mouse cursor here, he was walking down the 200 hallway towards 233, 237,
Yeah, he was walking that direction.
that direction.
Yes.
Did you watch where he went?
No.
What did you do?
There was a student who was injured, so I went to him. I knew he needed me.
And I know you're aware, but there's been certain rulings by the court, so just in general terms, did you render aid to that student?
I did.
Yeah, nobody
Did you
could
follow-
think that it was
did you do that
Ethan.
point?
Not the teachers, not the counselors,
him?
not the parents. Yet
Yeah,
they want
I
to hold the
knew
parents.
another one of my students from Lakeville. Tate near. Just took my breath away.
You were on the walkie-talkie, you said?
Yes.
That's good testimony if they didn't think they couldn't believe it was him.
So I let them know I had
Yeah,
let them
I
know
mean,
I
I
had-
might press on that a little bit.
eyes on the shooter and that I had a victim.
I would.
Kurt News asked me where I was. It's probably the biggest hallway we have, and I said I was in the 200 hallway. Kurt let me know that's a very big hallway and needed more direction. I don't know why I couldn't process the fact that, like, my exact location, I told him I was near the 400.
Did you stay with Tate until help arrived?
Yes,
Now, you have seen at least a portion of the Oxford High School surveillance video, is that right?
yes.
I'm going to show you what's been marked as People's 9, been admitted. It cannot be broadcast on media.
I've never seen that, so you have to tell me.
The entire, this is a short clip of it. None of it can be broadcast.
No broadcasting of this video. We're
Yes,
just getting
okay, so
listen.
you guys are not video, okay. Everybody gets it?
So you shut it.
We're gonna stop the live stream? Should we stop the live stream? Yes.
Yes, Jeff.
Yes, please.
I do want to give notice to the jury as well. This is the moving image of a victim on this video.
I don't agree. I mean, okay. We understand that there's minors involved, so maybe it's a little different. But normally you should be able to see all the evidence, right? It's a public trial. Does James have an advantage to being tried after Jennifer? I don't know. I mean, well, he gets to see a presentation of all the evidence that's going to be used against him. So there's always the advantage to knowing what's coming.
Okay, Christy, tell us
And
when
if
we
they
see you.
convict her, he better
I
be
am
worried.
approaching right in the yellow jacket there, the gold jacket.
For the record, this is at 12:51 PM on November the 30th. So no one's come by at this point.
No,
James's trial is March
I got about-
3rd.
that's when he came by. He said, get the hell out of here. I don't know if you can see him running through
The
there.
first student.
And you see more students running. These kids are kind of laughing, and then you'll see me stopping. There we go. There's no
No, they have
walkie.
different lawyers.
You're walking down the
And I'm
hallway there.
walking towards the direction that the kids told me. They cleared the hallways very, very, very fast.
That's you at the top of the screen.
Yes, I didn't realize that we passed there. This is where the teacher came out I'm checking another classroom to make sure they were okay. And then continuing on.
There was one woman who openly said she votes Democrat. Everyone laughed. Judge said, I didn't ask you that. I don't think she made it to the jury.
This is where I'm saying, that's when I stepped aside, that's when I said I had eyes on the shooter, because he flinched a little bit, at least in my perception that he did. This is where I moved the garbage can. That's Tate.
If I had my guess, I would say the defendant.
When
the
I'm
witness
talking on
is
the
the-
walkie, I try to step back a little bit because I think it threw Ethan off a little. And so there he is coming up to me. And I start talking to him here. And I'm letting them know that I have a victim and I have a shooter. I'm asking him questions. And I turned my back on him and I came back to Tate because I didn't know it was Tate then. And then that's what right there is when I know it's Tate.
It's a video of the hallway with Ethan, a victim, and this witness. She approached Ethan and said, hey, come this way, there's a shooter. Then she realized that Ethan was the shooter. He turned
he's
around,
arrived on
walked
scene,
away,
and they're
this
trying to figure out
witness
his
went
name.
and helped the victim.
Yes, and so I left Tate to go tell them who it was, and then I went right back to Tate. I did not want to be away from Tate. I was telling Ken, his name's Ethan.
Thank you for saying that.
The defense attorney has been objecting the entire time. She filed
You can resume, they can resume the live stream, right?
she filed the motion to exclude. She put objections all over the place this morning.
I'm sorry, I can't be.
Judge's
Oh,
ruled.
yeah, I think he said that he's.
Yes.
Okay. I have no questions for you, I'm sorry.
Thank you.
Can this witness be started?
All right, on to the third witness. Yeah, no cross was appropriate.
Oh, you're right. She looks way different.
Right? I told you, old grandma.
Is there a way we can have like a minute?
Say again.
I'm like so sorry, can we just have a minute, like a break or can we just have a break, please?
The defendant is uncontrollably crying.
All right, for the jury.
I got to get all my crosses on and directs on lined up. This is going to go quick. The judge did say that this was going to go very quickly once the case starts.
Can
we talk in chamber chat? I just need my client to have a minute to like.
Okay, sure. I guess I want to, you could probably be seated. I want to confirm with the deputies. I've done about a bajillion trials with the courthouse. I wasn't always under the understanding that the defendant would go downstairs every time to take a break. But is that what you're?
I've been ordered by my sergeant.
Okay, well, all right.
It's a holding cell in the
Okay, so
basement.
you have to take her downstairs right now. Is that correct? Yeah. Okay.
I take her all the way down to the basement.
All right.
Is there something you want?
Yes.
Good. Okay.
Yes, I'm gonna record. Can you go on record?
Ariana, you can go back on record. Okay. You want to be on record?
Yes.
Okay. You can be seated.
Let's slow it down.
Okay. You are on the record.
Your Honor, this court, upon the defense's request, instructed the prosecutors not to show emotion. You instructed the prosecutors to tell our witnesses not to show emotion, and you instructed us to let our victims know. I understand the ruling, Your Honor, I do. You're concerned about influence of the jury. I take no issue with it, but it was a difficult thing. It's difficult, and we're doing it. And then to have not just the defendant, her lawyer sit there sobbing so that.
I did not sob.
I just want to finish, Your Honor. I just want to finish. I just.
Sit down, Karen.
I think.
God.
If that is the
Ugh.
instruction, we are trying really hard to respect the court's instruction because I understand the reason for it.
Okay, I didn't tell people not to show emotion. Some of that is involuntary. But there are good times in this courtroom during trials when people will show facial expressions or or, things like that. or-
Uncontrolled
or make
crying.
Comments. I understand, this is a very emotional situation for everyone here, right? If someone was audibly sobbing in the audience, I would hope that they would exit. And as you said, the reason for it, I didn't tell anybody not to show emotion. I guess some emotion is involuntary, so I guess I'm asking what you're asking.
I think it should apply to both sides.
Oh,
Your
is it
Honor,
a bad
first of all,
look
I was not sobbing.
for you?
This is horrific. This is
I've never
horrific.
seen this before.
It's
Okay.
horrific. That's
Okay.
why we asked the court not to play it. This is horrific. I don't know how the
But
prosecutor.
if the victim-
She's watched it 100 times with these witnesses. It's horrific.
You've had this video for over 2 years.
I don't know. I don't have this video. I have to go to their office to watch it.
You've seen it.
No, I haven't, because it's not necessary, it's not relevant to my client's case. We've already litigated this, but we're doing our best. We were not sobbing or making the scene in any way. All my eye makeup's still on. I checked my camera.
I'm not having.
I need to run to the bathroom. I need a break.
I don't want to. I'm not having this conversation. You started it, prosecutor.
I'm sorry.
She sure did.
I'm sorry.
Okay, all right, everyone here is human, right? Everyone here is human, I understand that, I'm striving really hard to give both sides a fair trial, and if people don't at least try to check themselves, to exit if it's that excruciating, which I know it is, I'm not a robot, I'm trying to keep myself from sobbing, I'll do it at 6:00 tonight, okay?
I appreciate that, Your Honor. That's all I'm asking.
Okay.
That's all I'm
Your Honor,
asking.
we don't have the option to leave the courtroom. We're trying our best. We're trying, I promise you, we're trying our best. Thank you.
Everybody needs to take a deep breath. She needs to go downstairs, right? And we're gonna call you right, have a
I want to know what
conversation.
Jung thinks about controlling your
The
emotions.
next witness is, I'm bringing lunch in for the.
Next witness is Cammy back. I anticipate very brief questioning.
Okay.
Cammy
So I'm-
back?
I'm having their lunch delivered, so they don't have to commingle with people in the cafeteria.
It should be less than 30 minutes.
By the way, it's a very nice cafeteria.
Are we gonna break the neck for that witness? Okay, thank you.
I enjoed my sandwich.
I apologize.
Well,
I miss not being there every day.
It's
It's horrifying.
It is horrifying. But
We're trying,
okay.
We'll keep trying.
All right.
What a ridiculous comment for Karen to make.
I know.
Well, you told us to control our emotions, and now they're sitting over there crying.
Well, the judge make it sense too, because she was like, I meant like facial expressions, stuff like that.
Yeah, don't grimace. Don't, do things
Yeah.
like that.
Jesus, what a dumbass.
It's getting heated. Tense moment as the prosecutor scolds the defendant for crying at her own trial.
Yeah.
After seeing her son on video holding a gun, standing over a victim, God forbid the mother of that shooter shall cry.
Yeah. Because
That's what she's looking at, by the way.
Yeah.
Let's talk about what she's looking at. She's looking at her own son standing over a victim after having just shot that victim. You're telling me that you expect this mother to not cry, but then put her on trial for not doing enough for her son.
Exactly.
Which way do you want it, Karen? I'm going to turn it down a little bit because it's just people talking in the background. All right, Jamie. So of what you've seen so far, what are your thoughts?
I'm already irritated.
Right?
Well, I haven't really seen anything that is any relevance to why she's there, why Jennifer's there so far. And then
Well,
that
the fact that her
argument
son
just
shut up
made
the
me.
school, that is
Well,
an
no,
element.
I meant. Yeah. But I mean, like, in the fact of like, oh, I'm starting to, you know what I mean? Obviously, we're two people in, so it's not a big deal.
By way of just explaining what I'm doing going forward with this trial, I typically do a morning and an afternoon session. I don't do one solid long stream. So I already have the afternoon session set up. When I do end the stream, when they go to lunch, you will automatically be redirected to the afternoon session, which I have currently set to go at 1:30. Knowing this court's schedule, they tend to break for lunch at noon, and then they come back at 1:30. If the time changes, I will change it, and we'll go live when the court goes live. But when you guys get redirected over there, click the notify me button. So you automatically get notifications. And if you are a new member, or if you've been a member for a while, but you haven't been in my Discord, join the Discord. Tell Jung what your YouTube name is. And then I post notifications when we go live in there as well. Or at least my mods do. Somebody does. So you'll get a notification that way as well. So you don't miss anything going forward. Hey, McKinley. Closing arguments got... they're just mad that their closing arguments got messed up. Closing... I don't know what you're talking about. Did they show the video to us? No, they did not show us the video. The witness talked through the video as to what she was seeing. She had already testified as to what was going on. So essentially, she was out in the comments talking to the seniors. When she heard about a shooting, she went running down the hall, saw Ethan, and said, hey, come this way. There's a shooter, not knowing that he was the shooter. Then he stopped and he turned and she realized that he was the shooter. He didn't raise the gun and he walked away. Then the witness, who is the assistant principal, went and helped the victim lying on the floor. So that's the video that they watched. So again, the defendant is seeing her son with a gun standing over a victim that he just shot on that day for the first time. She started crying. And then Karen, prosecutor, has to, her name is Karen, I'm not just calling her that, has to stand up and say, oh my God, how you told us, judge, that we can't emote, and yet you're allowing this defendant to cry in court. This is nonsense. This is nonsense. You want her to be emotionally involved in her son's life, but you don't want her to cry seeing the acts that her son committed.
Exactly. And McKinley meant that Karen's just mad because, if she didn't cry, they would bring it up in closing.
Oh, yes, they would. Absolutely, they would. Look at her. She sat there stone-faced the entire time. She has no emotion. Yeah. I get what you're saying. Yeah. Screwed up her closing argument. Yep.
Yeah.
Court is so weird lately.
Well, it's true. Like, that's so stupid. And then she made a point to speak. And the attorney sobbing also. I've seen her wiping her face, but
I love the attorney's like, my makeup's not running, Judge.
Yep. She's got that good setting spray.
My makeup's not running. We're good. No raccoon eyes on me, Judge. But I like her attorney. I'm not a fan of her style all the time, but she's sharp. She's on. She knows what she's doing.
Yeah.
So I like her.
So far, what we've seen, I like her in the prelim stuff. So.
Yeah. She does do a little up talk, a little bit. We haven't really heard her questioning witnesses yet. Yeah, stare at that wall. That's a good wall. It's a pretty wall. We haven't really heard her questioning witnesses yet during this trial. She hasn't done any cross because there's no cross that's necessary. So, quick recap. Opening statements. I'm actually taking notes on this trial. Shows pictures of the victim. Talks about an act of terror committed by the defendant's son, despite the knowledge of his mental health. The mother basically did nothing and, in fact, bought him a firearm. Then the prosecutor shows the math worksheet. This is the math worksheet at issue here. Well, this is the original one. And then this is a cleaner one, but some of the stuff is crossed out. And then talks about that. Says that this apparently is proof that mom knew. Mom communicated her concerns to James. He goes over. The prosecutor went over text messages that that Jennifer and James had about this. Basically, she texted this to her husband, and he said, "Oh, we need to get him help." This is the morning of, people, the morning of the shooting. The defense opening statement quotes Taylor Swift.
Wait, what?
The defense's opening statement quotes Taylor Swift.
What?
Band-Aids don't stop bullet holes, which it's fine. Maybe not reference the fact that it's Taylor Swift. Band-Aids don't stop bullet holes. What she's saying is that the state is charging Jennifer in an attempt to make people feel better. Put a Band-Aid on a broken bone. It's not going to do anything. And send a message to gun owners. I agree with those two statements.
Yes, that's actually I agree.
She said that there's going to be graphic evidence of the shooting, which does not need to be shown. She said that in her opening statement, but the state's going to show it to you anyways. Jen did not have on her radar any idea that her son would be in a position to shoot people at school, or had a desire to do it. Let's see here. Oh, most importantly, she said slivers of evidence from a forest of trees is all that the state has. Slivers of evidence. I like that statement. Slivers of evidence. Because if you remember the preliminary examination, there was like 4 foot tall stack of messages. And the state pulled out one here, one here, one here. 25,000 messages. 25,000 messages, and the state presented like 5. They said, see, he's talking about it. Mom should have known. 5 out of like 25,000 messages. Now, if you're a parent out there, tell me that you know every single message that your son sends to anyone. If you don't know all of them, then you have to acquit this defendant. So that was, but I like the way she phrased it: a sliver of evidence, or slivers rather, slivers of evidence from the forest of trees.
Yep.
She said that the defendant is going to testify. She also said that Ethan's going to testify, but Ethan has placed everyone on notice that he intends to plead the fifth. So if he doesn't testify, if he pleads the fifth, he's obviously not going to be able to testify. That might cause some problems for the state admitting Ethan's journals as well as his messages, because there's no proper way to cross-examine that if Ethan doesn't testify. So that'll be interesting. There's going to be a battle about that when we get past this whole shooting thing happened. First witness was Molly Darnell, teacher at Oxford School. She was actually shot in the arm. There were some photographs showing of her classroom with bullet holes through the door, one in the window. She said she was sitting in her class. All of a sudden, she heard a commotion. The kids were running. Then she said, then the witness started crying, talking about thinking that there was a fight, but saw a bunch of kids running out door 4, which was unusual. I don't know what door 4 is or why it's unusual, but it was. She heard 3 loud pops. She thought it sounded like lockers closing, but they weren't using lockers because of the vid at the time. Then they introduced some photographs and a video. The video was simply the teacher walking down the hall with police officers. We saw that one. It wasn't really anything special. And that's about it. No cross on that teacher. And then we just finished the second witness, who was the assistant principal at the school. And we just went over that testimony as well. Again, no cross. And then we blew up into the giant argument regarding the defendant crying. I'm making notes, so you could talk, Jimmy.
I don't know. I just don't. It sounds good. The Taylor Swift thing makes me laugh, but I get where they're going with that one.
I just love the fact I'm a Swiftie. I love Taylor Swift, but she's not everyone's cup of tea. And
I don't
get
hate
that.
her. I just think it's funny to like quote her in a murder trial. But
Yes, I am. If I catch your question, if I miss your question because I'm busy like talking or looking at something, feel free to post it again.
I'm trying to look for you here.
Was it necessary for the state to have this video shown? It wasn't necessary. The parties stipulated to it. The state's doing it to get an emotional rise. Technically, the state needs to prove that a shooting happened. They need to present some sort of evidence. Even, you don't have to rely on the other side stipulating to a fact. You can still present your evidence. I think, from my limited knowledge, I believe these are the only 2 like teachers or school employees that are testifying. So maybe we're done, but I doubt it. I have a feeling that there's going to be police officers, sheriff deputies that are going to testify about the school shooting. So there's probably going to, this whole day is going to be taken up with, did there or did there not have a school shooting in Oxford High School? Wilfram, thank you very much for the $5 super chat. DA Karen whining about defendant crying and looking sympathetic. And yet she is putting crying witnesses on the stand, which is sympathetic. Yeah, well, she's complaining about it because it's not good for her side. Yeah, I wonder. I didn't catch any Swiftie remarks when I was in court listening to the jury the other day, but maybe she picked up on something.
Well, it's like you said, exactly what they're doing. They're just trying to make everybody feel better because they want to hold somebody accountable. It's always that. You know. I did see someone ask, is it normal to have 5 alternates?
No, normally you would have like 2. Normally a panel, like a jury of 14 with 2 alternates. But this is a high profile case. There might be people that get sick. It might go a little bit longer than normal. Most trials last like 3 days, right? So this is going to be a 2 to 3 week trial. So they had to move in 2 extra chairs, in fact, to accommodate everyone. That's why there's 2 jurors that are sitting almost on top of the witnesses. And the one witness, when she was rolling up her sleeve to show her scar from being shot, the camera turned a little bit and showed the notepad in the hands of one of the jurors, and Brandon Lesko was like, yeah, they're definitely going to show a juror at some point. They might, because they're so freaking close to the witnesses. They're practically breathing on the witnesses. It'd be like a witness sitting. Yeah. So the jury's sitting right about where my hand is, and I'm the witness. They're like right on top of them.
You can touch them.
Youpers and trolls. I saw something about Youpers and trolls. Where did I see that? I'm a troll. Let's see here. I need you to talk to her attorney and find out what eyeliner mascara she's
absolutely.
wearing. This is where I will ask her.
Like, tell us about this because that sounds phenomenal.
My makeup's not running. Oh, they turned the camera off or the audio off. If the defendant is found not guilty, could she sue the state? Yes. So there are 2 causes of actions: wrongful prosecution and abusive process. Both causes of action essentially require you to be acquitted of all charges. If you're found guilty of a lesser charge, if charges are dismissed, if you work out a plea deal and plead to something lesser or anything like that, those causes of action are barred. But if she gets a full acquittal, then she does have potential for wrongful prosecution and abusive process. So those are still out there.
Seen Ashton ask, how is this judge? I kind of like her so far.
The judge is very fair. In fact, the judge is very fair. I like her rulings in this case to some extent. Now, I believe that she should have just dismissed this case outright. But maybe she wants to take in the evidence and then do a directed verdict. I don't know. And not that she wants to do anything, but I mean, maybe that's what she's thinking. Well, I'm not going to dismiss it right now. I'm going to keep my ears open. She excluded the bullshit state's expert witness, which I'm so happy that was excluded. She has said absolutely the defense can use Ethan's medical records despite his objection. His medical state is an issue in this case. And so the prosecution didn't want it used. The defense asked for it. The judge said, yes, you can have it. She's a very fair judge. But on the same side, she said, no, the state has an obligation to prove every element, one of which is the fact that the shooting even happened, right? So I can't bar them from introducing that evidence, even if you do stipulate. So she's being fair on both sides. And I like that in a judge. I don't want a judge that's one way or the other. She'll leave it to the jury. Yeah, but she could also enter a judgment notwithstanding the verdict or a directed verdict. Yeah, it was the state's expert.
talk with me, but I just want you to.
Okay, thank you. Thank you. If you're bringing a candidate, well, I guess you might want to bring the jury in.
And again, if you guys missed my statement earlier, when they go to lunch, I'm going to shut this stream down, redirect you to the afternoon stream, and we'll go live again. Hit the notification button. So when I go live, it'll pop up on your screens, and you will know when we're live again. What's the judge's name, please? The judge is Cheryl A. Matthews. Honorable Cheryl A. Matthews. She's been a judge for a long time. Oh, who's this? I think this is a mother.
Is this a tiny courtroom?
It's not that
It
big.
looks-
Hey, Baker.
It looks very like.
The second I close this down, my screen.
This is. I think this is a mother of the victim. I'm gonna turn you up a little bit, Baker.
Hi, Baker.
All right, you may be seated.
Hey, Jamie. Just saw that you ran to New Day. I was told that as the streaming.
Baker was very jealous. He had to come running.
Yep.
All right, I got to get this lady's name.
Good morning. Good morning. Could you raise your hand, please? Do you swear to affirm the testimony about the evidence the truth so help you God?
Yes, ma'am.
Okay, you can be seated, and then the new state name for the record and spell your first and last name.
Cammy Back,
And spell your first and last name, please.
CAMMY BACK.
Go ahead, prosecutor.
Thank you. Ms. Back, I'm going to ask you to keep your voice nice and loud for me, okay?
Okay,
Now, is it true, Miss, that you work at a retail store that sells firearms?
yes,
And
Oh,
not
that's
true,
who she
Michigan?
was.
yes.
How long have you worked there?
4 years.
What's your current title?
Office manager?
Have you always been the office manager?
No,
As office manager, do you assist with gun sales?
yes, I do.
Okay. And what did you do before you became the office manager?
I was a counter.
I'm sorry?
I worked the counter,
Okay, the counter?
yes,
Okay, so you would deal with customers?
She's just a good
You're
old boy.
familiar with the procedure when someone purchases a firearm?
yes,
Now, there is a specific process when somebody purchases a handgun, is that correct?
yes.
Could you tell us a little bit about that, please?
So when you come in to purchase a firearm, whether it's a handgun or a long gun, we have to have your ID. You have to fill out a 4473.
What's that?
It's a federal firearms form for the
Okay.
customer. Once that is done, myself or whoever will run a NICS check on the computer.
Okay, can you tell us what that is?
That is where you send it over to, I just lost my train of thought. To the FBI, and then they take it from there.
This is
Okay.
a
Do you know what
repeat
happens
of her
with that?
I
preliminary
do not.
testimony.
So you take this information in and the customer fills out certain forms and you send that off?
Yes.
Okay, and how long does that process usually take?
Sometimes it could take seconds, sometimes it could take up to 30 minutes
Okay.
or longer.
Is someone able to walk in and buy a firearm, or to buy a firearm and walk out with that gun purchase that day?
As long as they pass the background check.
As long as everything checks out?
Yes,
Now, what happens if things don't check out, or if there's some kind of delay? Does that ever happen?
yes.
Okay, and tell me about that.
So if a customer is delayed, we are giving them a Brady date, which is 5 days. Within those 5 days, the NICS check could come back as a proceed, or it could come back as a denied. After 5 days, if there's no response, then we are allowed to hand the firearm over to the customer.
Okay. Do you know the circumstances in the background why somebody might be approved or denied?
I do not.
Now, when the store you work at sells a firearm, do you also provide a ATF?
Baker, does this make you want to buy a gun?
Yes,
Is that with every handgun purchase?
with every handgun, yes.
Okay.
That's the only reason I'm
Tell me
coming to
about that.
Tennessee is to
What
shoot
kind of
with them.
information is contained in there?
It just states, the do's and the don'ts, as far as, you know, when you buy a firearm,
They
child
did, John
safety,
H.
how to lock it, just to pretty much keep your firearm safe and out of the hands of, you know, anyone that doesn't need to have it.
Okay. And that is provided by the ATF?
Yes,
Okay. That's the Bureau of Alcohol, Tobacco, and Firearms?
yes,
Does your store also provide a trigger lock statement?
yes,
Okay. And is
Baker's
that
from
one of the
Denmark.
standard forms that has
Where
to
only
come
the
with
criminals
firearm
have
purchase?
guns.
yes.
Can you tell me what that is,
Yes.
please?
So it
Make it
just,
safe.
the trigger lock form, we take and we make sure we check the box, that it has the lock in the box and that it has a box that can be locked,
Okay. Now we say the lock in the box. What do you mean by that?
the trigger lock.
Okay, so when your store sells a firearm, you also provide a lock with it.
Yes,
Okay. And that's not an actual gun safe, correct? That's a smaller locking device.
yes,
All right.
They're going to
And
use
that
this
happens
witness
with
to
every,
establish the fact that there was a
handgun
gun
sale
lock
from your store?
available.
yes,
I'd like to direct your attention to
And that it
November the
wasn't
26th of 2021. Do you remember that day?
I do.
Okay. And were you working?
Yes, I was.
Did you, well, first of all, I should ask you, as office manager and someone who's been employed at the store for 4 years, every time a firearm is sold, is there a receipt kept?
Yes,
Okay. On November the 26th, 2021, did you sell a handgun to James Crumbley?
I did.
And was he there with somebody else during that purchase?
Yes, he was.
Okay. Was it an adult or was it a teenager?
Teenager.
Okay. Did you come to learn who that person was?
Later, yes.
Okay. And you came to learn that it was the defendant's 15-year-old son?
Yes, sir.
Okay. But you didn't know that at the time?
No, I did not.
Okay. Now, during the purchase between yourself and James Crumbley, did his son do anything?
Never.
Okay, so he was there present, but he didn't interact with you.
No.
I'd like to direct your attention also to June the 15th, 2021. Did James Crumbley make another purchase of a firearm that day?
That I cannot say.
Okay. If I showed you receipts, would that refresh your memory, you think?
Yes.
Okay. So what I'm going to do is go through some exhibits with you. They'll be on the screen in front of you. These are all stipulated too. Can you see that?
Yes.
Okay. This is exhibit 24. This is, do you recognize this as a receipt from the store you work at?
Yes.
Okay. This is June the 15th, 2021. Do you see the date?
Yes.
All right. And the purchaser is James Robert Crumbley.
Yes.
Not at
It
the
has
time of
address.
the puke
It has
viewing.
the item purchase, and that's a Cobra Classic for $180 total.
Yes.
And
See how cheap
that's
that is,
actually a
Baker?
22 Derringer
What?
pistol. Is that correct?
Yes.
22 Derringer for only 180
24
bucks.
has been admitted, I believe, with stipulation.
Yeah, yeah.
I believe that this.
I could buy that. I just got some money.
That's correct.
Ooh, look at that. $1,000 bill?
No, no.
Thank you, Jeff.
Oh, no, it's $1 million.
This is exhibit
It's a million.
25 right here.
Don't take that to the
It
U.S.
says
That's
pistol
honorable,
sales
sir.
record. Can you tell us about that, please?
So each time that a pistol is sold, we have to provide the customer with a pistol record. They are given those and they are instructed
He's
to
throwing
have
out all
those
of his
dropped within
information.
10 days of the purchase.
Redacted his date of birth.
Now, this
I don't
has
think
a
that phone number
description of
works
the
anymore.
pistol, is that right?
Yes,
So it says, this is the Cobra Classic, we just saw the receipt for. Do you see that on there?
yes,
Okay, and it says pistol shot in the number 2. What does that mean?
it's a 2-shot.
Okay, so it's a small handgun,
Yes,
and barrel length 2.25. Is that in inches?
yes,
Okay. It says purchase transfer date is June the 16th of 2021, whereas the receipt was June the 15th, 2021. Can you tell us what happened?
So I believe that
Supposed to lock
Mr.
the gun so
Crumbley
it
may
can't be
have
played.
gotten a delay on June 15th.
There's a bunch of different
And
styles.
he had a proceed either later in the day on June 15th, or he may have gotten a proceed early morning on June 16th.
Okay, and that's because there's some kind of delay in the background information?
Yes,
Ms. Mack, is it true that some handguns sold by the store actually come with their own cable locks, not just from the retailer themselves?
Yes.
Okay, so whereas on November the 26th, you provided a lock, not every handgun has to be provided a lock by your store.
Yes,
Because
it does.
Because the manufacturer gives the lock themselves.
Yes.
Okay, so I don't think that was clear, so I just want to back up for a second.
So some guns that come in from the manufacturer do not provide locks. We
Okay.
have to provide those.
Got it.
Sorry.
Okay, for all you Australians, there's two different types of gun locks, really. There's the type that clamps around the trigger. You're not supposed to be able to pull the trigger. And then there's another type that goes through the barrel and through the slide so that it can't actuate and actually lock a bullet in the slide and be fired. So there's two different types. And they're talking about that that they give them away, or sometimes give them away, with firearms. They're using this witness to establish the fact. I paused it in a really bad spot for her, but they're using this witness to establish the fact, really, that the gun was purchased and that it had a lock that came with it, because they're going to point to the fact that the lock wasn't even ever opened, meaning it was never used. That's going to be the state's position.
No, that's okay.
A slide lock wouldn't work on this case because it's a Derringer.
Well, for
That's
that
the
particular
problem.
gun, yeah, but the one that was used, the 6-hour semi-automatic, the slide lock, the barrel lock would work.
Yeah.
But in fact, it came with one, but it was never used because it was in the sealed package. So the state's position is they couldn't have used any other gun lock. It was only the one that would have come with this gun, right? It's not like they sell them separately. That one was used. It's just a dumb position to take, but it is what it is. So this witness is literally going to be out there to get two little bits of information, but you got to go through all this testimony to get there.
Right.
That's my fault, not yours. The 6-hour, for example.
You missed all the
do not
drama,
provide your
M.
own
Young.
locks, is that right?
Some they do, some they do not.
There
Okay.
is no storage
And if
law.
they don't,
Yes,
then you would
no
fill in that
storage
gap.
law.
Yes.
Now, this is Exhibit 26. This is a receipt, James Robert Crumbley, June the 16th. And this is the Caltech P17 22 LR. Total price $349. Do you see that?
Yes.
Okay, this is
It's a little more
26.
expensive.
And again, this is June the 16th. That's the day that he would have received the Derringer.
Yes.
You're right? Okay. And here's Exhibit 27, which is the actual pistol sales record. And again, purchase transfer date, June 17th of 21. So there was a delay in this purchase as well.
Yes.
Or don't use either because you
And
never
this
know when you will
description
need it in
is-
self-defense. You don't want to be
It's a
fiddling with a code
16
or a lock
shot,
or anything.
barrel length is 3.8 inches.
Yes.
So it's bigger than the Derringer.
Yes.
Now moving on to Exhibit 28. This is from November the 26th.
I think I have
of
like a
21, the
trigger
Derringer
lock
article.
from when I first bought mine.
So this is a receipt, total of $519.35. Again, James Robert Crumbley. Is that right?
Yes.
Okay. And this is the day you recall seeing somebody with it.
Guns are
Yes.
getting more and more expensive.
Do you recall if the son was with him in June, or did you not complete that purchase?
I did not complete that purchase.
Okay, that's fair. As office manager, you can tell us that those records are from your store.
Yes.
Yeah, we're establishing that it was a legal purchase. Absolutely.
Here's Exhibit 29. This is
But
the
it's
pistol sales record.
purchased by the
And this
dad.
is from
Yeah, legal purchase by
the
the dad.
6 Hour on November 26th. Is that right?
Yes.
Okay, so this is a 15 shot and it's 3.75 inch barrel. Is
Yes.
that right? Okay. And he walked out with that gun on November the 26th, 2021. Because that's the date that we have right there?
Yes.
Okay. Now, hypothetically speaking, if there was a 15-year-old who walked in your store and tried to buy a handgun, would you?
Our
let him?
hypothetical question is
Absolutely not.
appropriately. She's
That
not
would be-
qualified as an expert.
Here's Exhibit 30. This is a portion of the firearms transaction record. I think you referred to it as a 4473. Do you recognize this?
Yes.
Okay. And was this provided, this was filled out by James Crumbley?
Yes.
Okay. And what's the purpose of this form here?
That is to keep a record for ATF for all firearms that are sold.
So there's certain boxes are checked here, and the condition of the gun is notified. In this case, it was used.
Yes,
Okay. And the purchaser has to assert certain things before he can walk out with that gun. Is that right?
yes,
In one of those boxes, are you the actual transferee, or you are the actual buyer of the gun, and it's not for somebody else?
right,
Because it is not legal for someone to buy a gun for somebody else through your store, correct?
no, it is,
Well, that person has to come in and fill out this paperwork, is that right?
yes,
Right. So it would not be legal for a adult, for example, to check this box that the gun is for himself and then transfer it to a child.
yes.
Yeah, this was established all during a preliminary examination. The gun was purchased completely
Can
legally.
you tell us the difference between a cable lock and a trigger lock?
So
Oh,
a cable
here you go,
lock,
for all you
you
Australians.
have to take the slide off of the pistol and run the cable through the barrel and bring it out and to lock. Trigger lock goes directly on the trigger.
Okay. And do you recall
Where's
what
the
was
evidence of that,
provided
Brent?
to James Crumbley and June?
Show me the evidence, Brent.
November the 26th?
I believe it was a cable lock.
A cable lock, okay, so it looks like a rope.
Yes,
And then at the end of the rope, there is a locking mechanism,
yes,
and then that's fastened by a key.
That's what they're going to try to
Correct,
say, but there's no evidence of it, at least that I've seen in all the hearings and the evidence that I've gone through the preliminary examination.
There's
There's
some
no
firearms
evidence
that
of this.
can't be secured with a cable lock versus trigger lock, or is it unique to certain guns that you need one versus the other?
I don't believe so.
Does your store always provide either a cable lock or trigger lock, or does it depend?
We provide both,
Both. okay.
yes,
But on this particular occasion, on November of 2021, it was a cable lock.
it was a cable lock, yes.
I have nothing further. Oh, hang on one second. Sorry.
Does David know you come and
Thank
visit?
you, Judge. Nothing further.
Broken Picker, does David know you come and
Thank you,
visit?
Your
right?
Honor. I just want to go back through
Good.
the exhibits.
Yeah,
Easiest if I have the
we're just
prosecution
writing in German,
go
so
back through them,
all
and
you
I
guys
ask-
can
or is it
follow
easier if
along.
I just transfer it to my laptop? Okay. Very good, please. Okay.
Did you see
can
the
pull
question
up
from
Exhibit number 24,
Chick
please?
Papi?
No, I didn't.
Chicky
What was the
Papi?
question?
Based on the guns M16, MR16, I think they probably AR16. I don't know, M16 destruction. Why not call an automatic or machine gun? Because an automatic
not.
is because that's hold the trigger down and it goes and a
Yeah.
machine gun is a big gun.
Yeah, a machine gun's a big gun, and this is a semi-automatic handgun, so they're calling it what it is.
Yeah, but it has to go when you pull the trigger. This is multiple trigger pulls.
Yeah, it only fires once per trigger pull. That's semi-automatic.
Just so that the jury can see it. And if you want, I can put it on my computer. I have them.
We have another flash drive that we provided.
I have them on my computer. Do you want me to take the reins and use my laptop?
Yes.
Yes.
Okay. Your Honor, we just need to switch this over then. Hit that button, and then I've got to plug in my,
It was fully semi-automatic. Get it right? Yeah, fully semi-automatic. Yeah, I know. That's how the politicians talk. It was
Yeah,
fully
was it-
semi-automatic.
Was it black? Those are worse because that's why AR-15s are so bad.
Oh my God.
Well, every gun is destructive. Every car is destructive. Every bottle slapped across a skull is destructive. Every fist thrown, every kick thrown is destructive. Everything is a
Yeah,
weapon.
there were some jurors that talked about, well, you know, a gun is different from a kitchen knife, because that was one of the examples. Like, well, if, you know, would you go hide out your kitchen knife? Well, a gun is different than a
Good
kitchen knife.
afternoon.
That juror, I think, was good.
My name is Shannon Smith and I represent Mrs.
No, it's
Crumbley.
not.
I'm gonna ask a couple of questions, and if I ask anything confusing, can you please just slow me down and let me know?
Sure.
Okay, thank you. It's not my job to confuse you. I want to make sure you understand each question I ask.
Okay.
The first exhibit the prosecution showed, Exhibit 24, which was admitted, is a receipt for a Derringer gun. And I just want to be clear, that Derringer gun was purchased by James Crumbley, correct?
I cannot say.
If you look at the receipt,
By the receipt, yes.
okay, so by the receipt, it indicates James Crumbley purchased the weapon.
Mhm.
And
Is that
it's,
Yes, I'm sorry.
and it's fair to say that Jennifer Crumbley's name does not appear anywhere on that receipt.
No.
Okay. We talked about exhibit 25, the pistol sales record. And this was the pistol that was bought back in June of 2021. On this receipt, or I'm sorry, on this pistol sales record, James Crumbley is the person who purchased this pistol. Is that correct?
Yes.
Jennifer Crumbley's name does not appear anywhere on this pistol sales receipt, correct? I'm sorry?
No.
Thank you.
Wait for the full question before you answer.
All right, exhibit 26 was admitted. This is a receipt from a Kel-Tec gun that was purchased, correct?
Yes.
And again, on this receipt, it indicates that James Robert Crumbley purchased the gun,
Yes.
and Jennifer Crumbley's name does not appear anywhere on that receipt.
No.
Decent enough cross. I like where she's going with this.
All right, I'm turning to exhibit 27, which was admitted. This is the pistol sales receipt from the Kel-Tec that we just talked about in the prior receipt. I'm sorry, this is the sales record. The sales record indicates James Crumbley bought this gun,
Yes.
okay? And Jennifer Crumbley's name is not listed as the purchaser, or she's not anywhere on this record, correct?
Yes.
They can, but they won't, Ace. It's going to be too risky for him to testify. He'd just plead the fifth.
All right, I'm going to number 28,
And
which
vice
has
versa.
been admitted. This is the receipt from the Sig Sauer that was purchased in November of 2021, correct?
Yes.
You have a direct memory of the purchase on this Sig Sauer gun, correct?
Yes.
And on this receipt, this gun was purchased by James Crumbley, correct?
Yes.
The receipt does not have Jennifer Crumbley's name.
No.
And when
just
this
say,
gun was purchased,
You can do some harm.
James Crumbley,
As the
This
baker
is-
holds up knives.
This is my bread knife with totally legal serrated edge.
It looks dangerous. It looks scary, Baker. It looks scary.
Yeah, it's
Yeah.
I want to
scary.
see that.
Put it
You're
away.
scaring me.
No, but it's just to people saying, "Oh, they're not that dangerous."
They're very dangerous.
What is it? Below 5 feet, a knife is more dangerous than a gun.
There is
Oh,
no minimum
absolutely.
age. There's no minimum age. They just have to be accompanied by a parent. I took my son shooting when he was like 4, playing around with stuff. Obviously, you can't
Well-
hold the rifle, so you put it in position, you get behind them, whatever.
Both of these are fully automatic because you don't need to reload. I do the Britney Spears thing.
Oh, Lord.
Oh, can you get in your bikini and dance like Britney Spears for us?
Would you?
I'll be right back.
it was accompanied by a teenage boy and no one else, correct?
Correct.
And you were testifying that you didn't have any interactions with the teenage boy who was with Mr. Crumbley.
Correct.
And when you saw this teenage boy with Mr. Crumbley, there was nothing about him that stood out to you as unusual or weird or something that would have raised concern about selling the gun to James Crumbley with his son,
No.
correct? I'm sorry, the court's making a record, so it's really important we talk one at a time. I'm not trying to cut you off in any way.
Oh, okay.
I just need to make sure the record's really clear.
Sure.
So I'm just gonna re-ask, and I'm doing it just to have a clear record. When you saw Ethan Crumbley with Mr. Crumbley buying the gun, there was nothing about him that concerned you about selling the weapon to Mr. Crumbley, correct?
Correct.
And on that date, you vividly remember it was only the two of them at the gun store purchasing that weapon, correct?
Correct.
Yeah, we're probably going to get
And
demonetized now,
again,
thanks to Baker,
on
but he'll make
exhibit
it up.
29,
No, you
This
can
is
show knives
the
as long as you're not using them in a
pistol
threatening way.
sales receipt.
It's the same with
Jennifer
guns.
Crumbley's name does not appear
long as you
anywhere
don't find
on
the gun
the
on the
pistol
screen, you can show
sales
it.
receipt, correct?
Correct.
You guys think the defense counsel is pregnant? Is that
And
what
I'm
you guys
gonna
are talking
open
about?
exhibit 30,
Yeah.
which has been admitted. This is the firearms transaction receipt. This is specific to the November gun that was purchased, the Sig Sauer, correct?
Yes.
2 hours.
And on this form, James Crumbley is the only adult that filled out this form, correct?
Yes.
Jennifer Crumbley's name does not appear anywhere on this form.
No.
And the information provided was all provided by James Crumbley, correct?
Correct.
And you cannot sell a weapon to a 15-year-old who walks into your store if they came in and wanted to buy a
Yeah,
gun.
they called the wrong
correct?
witness. Or the wrong, yeah, they called this witness to the wrong
If you don't know the
trial.
answers to these questions, I can ask someone else, but I'm gonna ask you. When a parent buys a gun, a parent has a right to take their child to a shooting range, correct?
Yes.
A parent has a right to take their child hunting, correct?
Yes.
A parent has a right, when they own a gun, to allow their child to use the gun at things like a gun range or hunting or along those lines, correct?
Yes.
My son hunting
You
for the first time.
testified that
Had to
with
sit
the
with
Sig
him.
Sauer gun, it did not come from the manufacturer with a lock, correct? A cable lock.
That was a used gun.
Okay, so the used gun did not come with a cable lock in the case, correct?
It may have.
If it didn't, you provided a cable lock
Yes.
to that gun.
Yes.
And in order to take a cable lock off a gun, you have to use a key, correct?
Yes.
And the key it's not just any key, it's a key specific to that cable lock, correct?
Yes.
And in Michigan, there is no, as far as you know, and if you don't know, you can tell me and I can ask another witness, there is no requirement that a person has to store a gun in a safe, correct?
Judge, I'm going to object. That's calling for legal conclusion.
Well, it is.
If she knows.
Yeah.
I'm
You used her as an expert as well.
Great.
Either way, it's not appropriate for this witness.
Yeah.
Okay, we'll take care of that later.
Yeah.
Okay.
Ask the-
When you
ask the
sell
popo.
guns to people at your store, you also, you're not required to also sell them a safe for that gun, correct?
Correct.
I know
As
of
a
them, I don't know them
precaution, if
personally.
it does not come with a cable lock,
Not this one.
you make sure that every gun that leaves your store is sent out with a cable lock if one can be put on that gun, correct?
Cable lock or trigger lock?
Or trigger lock?
Yes.
Okay, thank you. There is not any time that you recall seeing Mrs. Crumbley at the store looking at guns, considering
why is
buying
he
a
talking
gun,
like the
anything
witness
along
is
those lines, correct?
late in
Correct.
French?
And of course, I
I
don't
don't
expect
know.
your
This is
memory
her
is
style.
perfect. I'm just asking by recollection, you don't.
She asked questions like this during the preliminary examination. It's just her style. I said I like her questions. Not a huge fan of her style, but it's not turning me off. She's not necessarily being condescending. I think she's just trying to be really precise in her statements, and it's just not my style. But I like the questions.
Recall that Mrs. Crumbley was in there.
She was not, no.
It's also not illegal for a father to bring children in or a teenager in with them to purchase a weapon, correct?
Correct.
Mr. Crumbley is not the only person who has ever been in the store purchasing a weapon with minors present, correct?
Correct.
And there is nothing that when you come to the door of the store that says minors cannot enter the store or look at what you have in terms of your stock, correct?
Correct.
May I have just a minute?
This might be it for the morning session. I was going to put a poll on it, but I might just wait.
I have no further questions. Thank you.
All right.
Just very briefly, Ms. Beck, I'm just going to clear a few things up. I'm afraid I wasn't terribly clear.
Sure.
First of all, after the shooting in Oxford High School, agents from the ATF that came and spoke with you, would that be right?
Yes.
Okay. And ATF, that's the government agency that sort of regulates the finance or the firearms transactions.
Yes.
Okay, at least to your understanding.
Yes.
Okay. And when you, well, first of all, let me ask you this. Do you recall on November the 26th when that Sig Sauer was sold to James Crumbley, if he shopped around at all or if he went right to that gun?
He went right to that gun,
And did he make any statements about that?
that he had had his eye
Your
on
Honor,
for some time.
I would object to the hearsay of the
Yeah.
co-defendant who's not present in this trial.
It's not offered to the truth of the matter, sir, Judge. It's not
No,
sure
it
you went right to that
is.
gun.
It is.
You just want to put it in the jury's head. It's not offered as anything.
He asked whether or not he,
Yeah.
around. He didn't look at anything else.
No, ma'am.
Thank you, Judge. And were you able to tell if that
Motion to
transaction
strike.
for the Sig Sauer on 11/26/21 was for cash or for credit?
It was cash.
Cash, okay. And you did that by comparing the receipts on November the 26th, and there were no credit or check transactions that have been made in the amount of $519.35.
Correct.
Thank you, Councilor Fisk.
Can I ask
Oh,
you,
God
there's also an
forbid.
exhibit 31.
Somebody purchases
Oh,
a gun.
that's gonna
with
come
cash.
through Agent Brandon.
Okay, I just wanted to make sure you didn't have. to,
Typical state
bring this up.
prosecutor and police. You purchase something with cash, you're doing it
Thank
illegally.
you.
Thank you, Judge.
You're up in nefarious. Sorry, what time did they say they're coming back?
We don't listen.
I'm gonna excuse her.
Thank you.
Thank you, Judge.
This should be the last witness before lunch. Then we
The
can
lunch
chit
is
chat.
here. Okay, the fact that we're, providing lunch doesn't mean that you can't leave the building or go out to your car or do things like that. I want to avoid any interactions in the cafeteria, that, could impact you. I don't want people talking to you, and I just want you to feel comfortable, all right? So, your lunch is in the cafeteria, as an hour. We'll come back at, you can return to the jury room at 10 after 1, lunches are in the jury room.
10 after 1.
Don't discuss the case.
It's an hour from now.
Don't go on Facebook.
Let's see if they, we're going to keep it up for a minute to see if they have anything else going on, any other motions, or if Karen wants to go full Karen or not on something else.
And so I don't like this. Well, and I even live in a socialist country where we don't have guns because only criminals use guns. But this entire buying a gun lawfully, you should know it would be used illegally. Or your husband buying a gun lawfully, you should know. That's just stupid. One of the things I wanted to do when I had my kids in the US the last time was go to a gun range to teach them guns are a tool. And you have to be careful around them, but it's a tool. You can use it. Because in Denmark, everyone thinks that guns jump out of a closet and just starts pew-pewing people.
Right. I mean, everyone thinks that. Okay. Well, we're on break. Okay, it is what it is. So, the juries in Michigan are allowed to ask questions. I'm actually going to call the clerk, and it jumped over to another feed. They killed the feed. I'm going to call the clerk and see why the jury is not being asked if they have any questions, because I feel like that would be the appropriate mechanism, unless the jury's been instructed, like, if you have a question, write it down and hand it over. And if they're not seeing anybody like raising their hand or something or handing out a piece of paper, the judge just assumes there's no questions and moves on without specifically asking the jury. So I'm going to find out about that, because the jury is allowed to ask questions in Michigan. We had some questions in the Megan Amirowitz case, which, interesting enough, Megan is a witness for the state. And I saw her on Tuesday during jury selection. I was
Really?
waving to her, saying hi. And in fact, I had seen her attorney earlier that morning when I had my own hearing, and I was talking to him about that and about her case. And then I went upstairs and she was there. I was like, oh, hey. But she was there during jury selection, and apparently she was there today as well until they sequestered her and had her removed from the courtroom because she's on the witness list. I have no idea what she's going to be on the witness list for. But if you want to know about that case, I interviewed her as well as her mother, and I followed her case, and I do have a whole playlist about that. That is the Sleeping Father murder trial.
That is really weird.
Yeah, very odd, very odd. As the trial is going on, the jury can ask questions. Yes, the jury is supposed to be able to ask questions of each witness. And
No
the fact that they're
way.
not asking questions is very odd.
Well,
Although maybe they
maybe-
don't have any questions. But again, the judge is not asking the jury if they have any questions. So
Yeah, maybe these witnesses just don't have anything to ask them. But that's
how many
cool.
days is this
I'm
trial
super-
expected? This trial is expected to go 2 to 3 weeks. That's what the judge keeps saying. But the judge said once the trial starts, we're going to go fast. We're through 3 witnesses already, including initial instructions to the jury. And the judge is going to make sure that this goes as fast as possible. The judge was adamant about this, that this case is going fast. All the other trials going on in Oakland County are stayed until this process is done. So there's 21 other judges or 22 other judges that are not having trials going on right now, at least not jury trials, because of this. So they want to get this done. They're going to be expedient about getting this done. Yeah. But anyway, so that's the morning. I'm going to send you guys over to redirect you guys to my afternoon session. I know Baker likes to talk and chat and all that stuff for hours on end. I can't do it. I want to go get something to eat. But click
What
the
did I do?
notification button. You didn't know.
What did I do now? I turned off my stream today because I didn't want to sit and paddle around for 4 hours while I knew Jamie's new dad was streaming.
You've had 5 days in a row of like verdict watch, and you're just sitting there chit-chatting about anything and
Only
everything.
35 hours. Don't make it more than it was. It was 8 days.
35 hours of Baker
7
just
days.
talking, waiting for a jury.
Well, it's really annoying to people I know, but it's really good to being a YouTuber that my mouth never stops.
Little Pill. So the prosecution says that apparently Jennifer had made statements to Megan while they were incarcerated together in Oakland County Jail. So that's why she's being called. I have no idea what those statements are, but that was the offer of proof made by the prosecutor. And he also said he didn't invite her to the courtroom for jury selection, nor today, and doesn't know why she's here, but she needed to be sequestered and excluded because she is still a witness that they intend to call. So this case has got all kinds of weird moving parts. Is the gun safe never obligated, for example, regarding a number of guns in possession? Never obligated. Never obligated. At least not in Michigan.
No, and again, what does it change? One pew is in the house. It's just a step. There's 25 pews. If one guy gets a hand on it, it doesn't matter if you have 1 or 25. He just needs one.
Yeah. The judge is elected here in the state of Michigan. They're appointed at the federal level, and each state is different. But state of Michigan, the state judges are elected. Federal judges are appointed just because it's federal and they do what they want. It's actually written in Article 3. So I don't want to argue for another hour. I'm going to take an hour break, get people on my That's most appropriate. We're going to decompress for like an hour. I'm going to get something to eat. And I heard, yeah, she said, die, motherfucker. That's what she said.
John's got jokes today.
Let's see. And if the storage law was in effect, the parents were technically in compliance. I don't know. There's been no evidence to the contrary, right? Just because there was a trigger or a cable lock not used doesn't mean that there wasn't a different one that was used. Just because the case was sitting open on the bed when the police arrived doesn't mean that it wasn't locked up and the son stole it, right? There's no evidence to show that it wasn't kept in a condition which the most liberal of people would think would be appropriate. So I don't know. Is there actually a verdict for the Treehouse case?
Nope. They've been deliberating just 2 hours and 2 hours and 10 minutes, I think.
Okay.
So they must be at lunch now. I don't know if they take the lunch and come back after.
I found my ibuprofen. Everybody calm down. Yeah. All right. That's good. Everyone, this case is going to it's going to affect a lot of people, and everyone's got an opinion about it, which I love. Bring all of your opinions here. Tell your friends that this is the place to watch this trial. We are going to be covering every inch of it. I'm not going to call Megan. I was going to have Megan on the show, but if she's a witness, probably not a good idea. Until after she testifies, if she's released from her subpoena and her obligation, I might have her on. So that'll be a good time. Anyways, I will end it here so I can go get something to eat. I will see you all back here at 1:10 p.m. Eastern time. And until then, enjoy your lunch. See you guys.
Bye.
When I was young, my daddy said, gotta keep one eye